Good morning, Your Honor. Ashley Lundy for the people. At this time, people would waive any conflict in this honorable court. The Office of the Public Defender. The people do not believe that any conflict exists. Make a waiver for the avoidance of all doubt.
Good morning, Your Honor. Hannah Mackey, requesting permission to practice under Michigan Court Rule 8120 under Public Defender Lauren Brown.
Then she's
Deputy
gonna do the
Chief.
waiver. She's actually gonna talk that much. We made her. We made her.
Catching it early this
I
morning.
he really wants me. I want to say no. So- Permission to practice.
Thank you. Your Honor, we waive any potential conflict between this honorable court and our office, and if any conflict were to arise, we would waive that conflict so that this honorable court could hear these matters.
Thank you.
Thank you, Your Honor.
Court, for its part, also does not believe this conflict either in the Michigan court rules or the cases decided thereunder. To the extent that a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Robert Braxton.
Andrew Childers appearing on behalf of the people, Your Honor.
Braxton.
Braxton, I'm sorry.
Braxton.
Yes, yes, sir.
Your Honor. Sorry.
All right. Hold on, Mr. Braxton.
Sorry, Judge. Then you're quiet, Your Honor. Normally I can hear you across the room, so.
I'm sorry, I'll yell. if you want.
That means he has a good voice, guys. Okay, so. Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Mr. Braxton, who's appearing via Zoom from the Department of Corrections.
Mr. Braxton, can you state your name, please, sir?
Robert Braxton.
Thank you. And you're requesting an adjournment?
Yes, Your Honor. I spoke with Mr. Childers, who's now handling the case. We're requesting an adjournment both for discovery as well as to try to resolve this matter before preliminary exam.
All right. Probable cause conference, March 6th.
That's fine, Your Honor.
March 6th, 2025, 9 a.m. Bonds will continue.
Thank you, Your Honor.
All right. Thank you. Thank you, Mr. Braxton.
Thank you, Mr. Braxton. Just call me, Mr. Braxton. Thank Thanks.
Court does call the case of the People versus Stephanie Woodall.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Woodall, who appears via Zoom from the MDOC. Ma'am, can you please state your name for the court?
Joy Woodall.
Thank you, Your Honor. There is a resolution in this matter to which my client will be pleading to added count 2, use of a controlled substance fentanyl, and in exchange, count 1 will be dismissed.
The court form that the plea form that the court has indicates that the defendant would be pleading guilty to the charge of use of fentanyl. The 1-year offense upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
Very good. Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
State your name for the record.
Stephanie Joy Woodall.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
I understand that.
All right. And understanding that, you still wish to plead guilty?
I do wish to plead guilty.
All right. I should also advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I understand.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I understand.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or remain silent and not have that silence used against you, and giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand all of that?
I understand.
You understand you're giving up your right to appeal of right.
I understand.
Are you on probation or parole? You are not.
I am not.
Correct. Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to flee?
No.
Anybody threatened you or coerced you?
No.
You're doing this voluntarily
I am doing it voluntarily.
and of your own free will.
Yes.
And because you believe that you're guilty?
Yes.
April 12th, 2023, at the location of 3025 Michigan Avenue, East Michigan Avenue in Ypsilanti Township, Washtenaw County, State of Michigan. Did you have fentanyl in your possession?
I did.
Had you used it?
Yes.
And did you know what you were using was fentanyl?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
The people are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be March 13th, 2025, 10 a.m. Judge Washington. Bond will continue. Thank you.
Thank you, Your
Thank
Honor.
you.
Ms. Woodall.
Court does call the case of the people versus Jerry Ashley.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Chinazi Carey Akinruli on behalf of Mr. Jerry Ashley. Mr. Ashley, state your name for the record, please.
Jerry Ashley.
Thank you.
Your Honor, if I could just speak to my client very briefly. Mr. Ashley, we're going to adjourn today. The prosecutor and I are still working on a negotiation, okay?
Okay.
So, Your Honor, we'd be requesting an adjournment.
Probable cause conference without objection will be adjourned March 6, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you, Mr. Ashley. Court does call the cases of the people versus Dale Miller, 3 cases.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Miller. Mr. Miller, will you please state your name for the record?
Dale Miller.
Got him.
Your Honor, the court should be in receipt of competency referral on each of the files.
Got it.
Thank you.
Requesting a forensic evaluation in all of these matters.
Yes.
Court will order a forensic evaluation. I will set a comp hearing May 15th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Sir. Court calls case People versus Sean Almond.
Christy Berta from the Attorney General's Office on behalf of the people.
Good morning.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Almond, who should be present via Zoom. Sir, can you please unmute and state your name for the record?
Sean Almond.
He's waiving.
That is correct, Your Honor.
Mr. Almond, you're waiving your right to a preliminary examination. Is that correct?
Yes, sir.
You understand that that is a proceeding where the people would have to show by probable cause that the offense is alleged or the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Pate.
Thank you, Your Honor. We acknowledge receipt of the information, waive formal reading. My client stands mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for
At 1:30 before Judge Conklin.
April 8th, 2025, 1:30, Judge Conklin.
Thank you, Your Honor.
Bond will continue.
Thank you, Your Honor.
Thank you.
Mr. Almond.
Thank you.
Court does call the case of the people versus John Boyer. 2 cases.
Good morning, Your Honor. Ashley Lonnie for the people of both matters.
Good morning, Your Honor. Good to see you. Robert Ellman on behalf of Mr. Boyer in both matters. Mr. Boyer, can you please state your name for the record, Mr. Boyer?
John Michael Boyer.
All right. I have 2 resolution or 2 plea forms.
That's correct, Your Honor. In case 24F31637FY, the defendant is going to be pleading no contest to an added count 2 of attempted resisting or obstructing a police officer, a 1-year misdemeanor and or $1,000 fine. In exchange for that plea, count 1, fleeing and eluding in the 3rd degree, the 5-year felony will be dismissed. Defendant must enter into 15th District Court's mental health court. I understand he's already been accepted. In the other file, 23F0062FY, The defendant is going to be pleading to added count 3 of attempt use of self-defense spray, the 1 year misdemeanor, contrary to 750-224D. In exchange for that, counts 1 and 2, both FA will be dismissed, contrary to 75082. In that file, the defendant must also enter into a complete mental health treatment report.
And that is my understanding of the agreement as well, Your Honor. And I believe these will be no contest pleas, and you should have both reports in your file there.
You and I have looked at them, so, all right. May I have him sworn?
Raise your right hand.
Right hand.
Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
John Michael Boyer.
All right. The Boyer, it's this court's understanding that you are going to be pleading no contest to 2 misdemeanor charges. Is that your understanding?
Yes, Your Honor.
The first charge is that of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
The other charge is the offense of attempted use of a self-defense spray. That is also a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court.
Yes, Your Honor.
Basis for the no contest, please.
Potential civil liability, Your Honor.
Sir, to the charge of attempted resisting and obstructing, how do you plead?
No contest.
To the charge of attempted use of a self-defense spray, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal outright.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
Court has been provided 2 police reports. First, in the case ending in 1637, the court has been provided and has reviewed Chelsea Police Department report for their case number 244277. And in the other matter, the court has been provided Chelsea PD report for their case number 24240. Any objection to the court having reviewed those reports?
No, Your Honor.
No, Your Honor.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
The court will accept the defendant's plea in case ending in 1637. Count 2, count 1 is dismissed. In the other matter, the court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and reports are ordered at 1483 probation. Sentencing in these cases will be March 10th, 2025, 9 a.m. before Judge Freshour.
Thank you, Your Honor. May we address bond very briefly?
Very briefly.
Your Honor, Mr. Boyer has been in custody most recently since right before Christmas. I don't believe his mother is here today, but she's been here in the past. He does live with his mother at home. She's assured me that she will make sure that he does everything he needs to do. I think possibly a release on a GPS tether could be appropriate in this matter, given the resolution.
He's going into the mental health court.
Yes, Your
Is
Honor.
that correct?
That's correct, Your Honor. And in the older file, which is the file that just led to the use of self-defense spray, he was gone on bench for several months. So I'm actually opposed to any change in his bond at this time. If the mental health treatment court decides that he's eligible and good for release, I wouldn't have a problem with Mr. Elman contacting Judge Rushhour's court and the APA assigned there to arrange that, but at this time, I'm going to oppose any change in bond.
I would have to agree with that. I think I'll let the mental health court make the determination as to release and under what conditions. So motion for bond reduction at this time is denied.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Neil Hines.
Christy Berta from the Attorney General's Office for the People.
Good morning, Ashley Moten, Assistant Public Defender, appearing on behalf of Mr. Hines, who appears on Zoom. Please state your name, Mr. Hines.
Neil Hines.
State your name.
Neil Hines.
He did.
Oh, I'm sorry. Say good morning. We're requesting a 1 week adjournment. The payments have been made, but they haven't been posted to his account, and then he'll be able to accept the plea offer.
What do you mean they
I'm sorry.
just hasn't gone all the way through to post to the account?
Yes, and also his bond should have been applied to the case, and it has not as of today, as far as I know.
Yeah, I believe the order was just submitted to the court for execution. The balance is quite low. I understand he did make a payment this week that is not reflected on the MISIS report as of yesterday. So I believe I don't object to an adjournment, but I think 1 week is not enough. I would ask the court for 2 or 3 weeks.
Okay, very good. That's what I
Fine.
was wondering, timing on that.
Okay.
If he's making the payments of doing that, probable cause, I'll adjourn to March 6, 2025, 9 a.m.
Thank you.
Thank you, Your Honor.
Thank you.
Thank
Bond
you.
will- Court does call the case of the people versus Logan Cyrus.
People, Your Honor. Mr. Burns Senior.
Your name, sir?
Logan Cyrus.
Thank you.
Your Honor.
Yes. Yes. All right.
Morning, Your Honor. Sorry about that. Sam Bernstein with and on behalf of Mr. Cyrus was present.
He's already stated his name. What are we doing?
We're asking the court for an exam, please. Discovery is complete.
And people would have their witnesses available the 25th.
We'll do our best, Your Honor.
Preliminary examination will be in person, February 25th, 2025, 9 a.m. That is before me. Bond will continue. Thank you. Court calls the cases of the people versus Samantha Warren. 4 cases.
Andrew Childers appearing on behalf of the people.
Good morning, Edward Drukas on behalf of Samantha Ryan, or Samantha Ward in 7-11. I assisted her with trying to get arraignments on all 3 other cases. I think the court. I assisted her with getting the other cases arraigned today.
Are these arraignments? Where is she?
I'm on 7-11. We'll need, I believe the public defender will step in on the other cases.
Yeah. Second is Warren. What is your case number?
This. 5099. I did write it down incorrect.
Got it. Okay. All right, Ms. Warren. You are before the court on 3 other charges or 3 other
Yes, sir.
files. All right. Let me just go through a brief arraignment with you on that. In the case ending in 5522, you are charged with the offense of home invasion in the third degree. That's a felony punishable by up to 5 years incarceration, a $2,000 fine plus court costs. That is alleged to have occurred on January 6, 2025 at the location of 508 South Division Street in the city of Ann Arbor. Do you understand the nature of those charges or that charge and the maximum penalty?
Yes, Your Honor.
All right. In the case ending in 5517, you are before the court on a complaint that alleges that on or about January 13, 2025, at the location of 336 South State Street in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did commit the offense of stealing or retaining without consent a financial transaction device. Do you understand the nature of that that charge, ma'am?
Yes, Your Honor.
That's a felony punishable by up to 4 years incarceration and a $5,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
In the file ending in 5516, you are before the court on an offense that is alleged to have occurred on January 10th, 2025 at the location of 350 Thompson Street in the city of Ann Arbor, Washtenaw County, state of Michigan. That offense being home invasion in the second degree. Do you understand the nature of that charge, ma'am?
Yes, Your Honor.
That is a felony punishable by up to 15 years and a $3,000 fine plus court costs. Do you understand all of that, ma'am?
Yes, Your Honor.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, Your Honor.
These are public defender cases.
Hannah Mackey on behalf of Mr.
You wait for further formal reading.
We do, Your Honor.
And how does your client plead?
Not guilty, Your Honor.
Defendant having waived formal reading, pleading not guilty, court will enter that not guilty plea. Demanding a preliminary examination, I will set this for probable cause. I will set, are you looking for an adjournment?
We are.
I'm looking for an adjournment to
waive timelines.
Yes, we do.
I will set a probable cause conference in these matters, adjourning the one and setting the other one for March 6, 2025, 9 a.m. And at that time, we'll set a preliminary examination when the case is ready. Anything else to bond?
No, Your Honor.
None for us, Your Honor.
Bond in these cases will be set in the amount of a $10,000 personal recognizance bond, all other standard conditions, including no assault behavior or possession of weapons. She's not to possess or consume any alcohol, recreational marijuana, or any illegal drug. With respect to, I'm also going to enter that she is not to go to the stated addresses in the one case of 508 South Division in the city of Ann Arbor. And in the other case, I believe it was the State Street address.
In Your Honor, there's a co-defendant. He's currently in the jail, so it's not. I'm not terribly concerned, but I would ask for a no contact with the co-defendant, Cedric Green.
Cedric Green?
Yes.
Yeah. Any response to that?
And we represent Cedric currently. If he's the co-defendant.
Yeah. He was up for prelim on Tuesday, and we had to adjourn it. But yes, your office, Miss Pate, I believe, was representing him on Tuesday.
Got it.
I believe there may be a conflict.
You think? All right. So I think his name was with an E at the end.
I think it's S-E-A. Oh, yes, you're correct.
All right. What I will do is I will order no contact with Cedric Green on all of these matters also.
Yes, Your Honor.
Okay. All right. This one is self-vision. The other one, I just need it from the complaint
Okay. And
on here.
I'll confirm the spelling of the name as well.
Got it. Okay.
And go down to MAC and have them appoint somebody right away.
Pardon?
You want us to go down to MAC and have us appoint somebody, have them appoint somebody.
If you think that it's a conflict, they could do that, and then we can change the files, but she'd have to wait because I'd have to know that. I think it probably would be wise so that on the 6th, whatever's going to happen is going to potentially happen. So, Ms. Warren, I'm going to ask you to wait
Yes, Your Honor.
online. I'm going to ask you to wait online. The public defender acknowledges that there is a conflict in them representing you at this point, okay? So what's going to
Yes, Your
happen
Honor.
is they're going to go down, check with the MAC office. We will then, there'll be a new attorney appointed. I'll sign an order of withdrawal for the PD. A new attorney will be appointed, but I need you to wait so I can inform you who that is.
Okay, I'll do that now.
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
That's adjourned. Yes.
Oh, perfect.
What now?
No, nothing. This is your next case.
Court does call the case, People versus Mason Hurst.
Ashley, people.
Public defender fellow Nicholas Buckovich for Mr. Hurst. Who's sitting here in hearings.
Mason,
Mr. Hurst, can you state your name, please?
Mason Hurst.
What are we doing on this today?
Yesterday, I received a competency report that indicating that Mr. Hurst is competent to stand trial. Not sure if the court was in the receipt of that report. I received it around 2 p.m. yesterday.
I don't have a copy.
I can forward a copy to the court.
All right. Mr. Hurst, well, yeah, get me a copy so I can review it and then we can take care of his case today.
Okay, cool.
So Mr. Hurst, I'm going to pass your matter briefly. They're going to have to get me a copy of the report so I can look at it. Thank you. Court calls case, People versus Jacob Jackson.
Christy Berta from the Attorney General's Office for the People.
Thank you.
Ashley Moten, Assistant Public Defender, appearing on behalf of Mr. Jackson.
Jacob Jackson.
All right. You're requesting an adjournment?
Yes, please. If we could get about a month, if possible.
Pardon?
Could we get about a month?
Need a whole month?
Yes.
He's going to make a payment and there's a plea.
Yes, he has to make a significant payment that he believes that he should be able to make within a month, so he can accept that plea.
Any objection to the 13th on behalf of the Attorney General?
No, Your Honor.
Probable cause conference will be adjourned March 15th, 2025, 9 a.m. Bond continued.
Thank you.
The
Thank
court
you.
said the 13th or the 15th, Your Honor.
The 13th.
Thank you.
Thank you. Court does call the case, People versus Taylor Lewis.
Morning. On behalf of Mr. Lewis, who's approaching. Taylor, name for record, please.
Taylor Lewis.
Thank you.
Judge, can we set this for exam, please?
Well, discovery is complete.
Yes, Your Honor.
People have their witnesses available the 25th.
Do our best, Your Honor.
Preliminary examination in person, February 25th, 2025. 9
Judge.
a.m. That is before Judge Barr.
May I address a tether issue very briefly?
Briefly.
Judge, I don't think the prosecutor is going to object to this. My client's wearing a tether. We've discussed this before. She's a top chef at Ford Motor Company, which is extremely professionally embarrassing to her. She lives in Wayne County. The alleged victim lives in Ann Arbor. It's about 40 minutes apart. There's been no contact on her side. The victim is continually calling her. We'd like to repair the relationship. That all being said, my client has not answered any phone calls. She's not a threat. She will not go to Ann Arbor except to meet here in the courtroom, Judge. And she's asking that because she's a professional at Ford Motor Company. It's truly embarrassing for her to be walking around as a chef wearing the tether. We're asking that you allow her to take that tether off.
I suppose incarceration is less embarrassing.
I'm sorry.
Never mind. Response from the people?
Your Honor, we'll leave it in the discretion of the court.
Well, other than court proceedings, she has no reason to be in Washington County, is that right?
No, I don't.
We're gonna need an order in. I will order that the tether can be removed effective today. The defendant is not to enter Washington County under any circumstances except for court-related proceedings.
Thank you, Judge.
Yes, sir.
This is probably a stupid question, but that also
Probably is. Go ahead.
seeing me at my office at Ypsilanti. I mean, this
That
is,
would seem to be a court-related proceeding.
that's what I thought. Thanks, Judge. Really appreciate your consideration.
Court calls case People versus Cameron Curtis.
Yes, sir. We'll be looking for. Stephanie Cannon on behalf of Mr. Curtis, who's appearing to my right. Mr. Curtis, could you please state your name for the record?
Cameron Gage Curtis.
You're requesting an adjournment.
Yes, Your Honor. We're just requesting a 2-week adjournment to do some additional investigation and negotiations regarding his matter.
Without objection, probable cause conference will be adjourned to February 27th, 2025, 9 a.m.
Your Honor, may I briefly address bond?
Briefly.
Your Honor, I am not asking that my client just be released. His primary issue is substance abuse. He just wants to get back into treatment. I'm just asking if the court would be so inclined to allow him to be released into inpatient treatment.
Any response from the people?
At this time, the people would reject, this defendant had a bench warrant from out of circuit court for failure to appear in front of Judge Slay. This is from RNO where he ran from the officers. So at this point, people would object to any.
Well, this is with the court primary practices. I understand what the people's position may be, but if his primary issue is substance abuse, I would permit, and counsel, you can prepare an order that he can be released to inpatient treatment if a bed becomes available, but on a GPS tether.
Thank you, Your Honor.
Court does call the case of People versus Mark Stewart.
Good morning, Your Honor. Robert Elman on behalf of Mr. Stewart. Your Honor, I know you have a busy docket today, but will you please briefly approach?
Just want to mess up my day. Come on.
Thank you.
Record should reflect we had a bench conference in this case. Court will adjourn this probable cause conference out to February 27th, 2025, 9 a.m. Bond continues.
Thank you.
Thank you, Your Honor.
Court does call the cases of the people versus Dion Baldwin.
Oh, Your Honor.
Okay.
We're good.
Morning, Your Honor. Edward Lucas on behalf of Deanne Baldwin.
You're requesting an adjournment?
I am, and I would like to approach with the prosecutor if possible.
Why? Never mind. Come on. Record should reflect we've had a bench conference in this case, and you're requesting a preliminary examination.
Yes, Your Honor.
And discovery is complete, and that people will have their witnesses to the extent that it is necessary. So I will set a preliminary examination in person, February 25th, 2025, 9 a.m. That will be, these will be before me. As to bond in this case, you're requesting his release at this time.
Yes, Your Honor.
And my understanding with the conditions, there's no objection from the people.
That's correct, Your Honor.
All right. So I will grant in both of these cases, the defendant's request for release. I'll set a bond in the amount of a $10,000 personal cognizance bond. I will also order standard supervision through community corrections, as well as a GPS location tracking tether. That all those have to be placed on prior to his release. Anything further?
No, Your Honor.
Not on behalf of the people.
All right. Thank you.
Thanks.
Can you fill that in?
Yep, and I can flash it. That's all.
Court does call the case, People versus Christopher Kukola.
Assistant Public Defender Jay Bellinger on behalf of Mr. Kukola, who appears via Zoom from Bureau of Prisons, Your Honor. I believe he appears via telephone.
Kukola, can you unmute, sir? I'm not. He's muted. I don't know what their setup is there. If you have access to the keypad for the phone, hit *6 to unmute, Mr. Kukola.
And Your Honor.
Oh, he just did.
Your Honor, you got us?
You got it.
All right, we're here. I have this is unit manager help. I have Mr. Kukul here for you, sir.
All righty, thank you.
And Your Honor, it's my understanding there's going to be a plea today. I don't believe the box was checked. I apologize for that. It's going to be a guilty plea. And my understanding of the offer is that count 1 will be amended to a use. He'd be pleading as charged to count 2, the reckless, and count 3, the DWLS, would be dismissed.
So he's going to be pleading guilty to the charge of reckless driving, the stated count, the added count 4 of use of a Schedule 1 narcotic, a 1-year offense. Upon his successful plea, that those charges, counts 1 and 3, would be dismissed.
That's my understanding of the offer. Mr. Kukola, did you hear that?
Yes, sir.
Is that your understanding of the offer as well?
Yes, it is. Absolutely.
All right. Mr. Kukola, I'm going to have to ask you to speak up a little bit for me, okay?
Yes, sir.
All right, thank you. All right. And there's no objection from either side to the defendant taking this plea via phone?
No, Your Honor, I can recognize his voice from our prior conversation.
All right, very good. Why are you moving furniture? Never mind. We'll talk in a minute. Mr. Kukola, can you raise your right hand?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely.
All right. State your name for the record, please, sir.
My name is Christopher Nicholas Cocola.
All right. Sir, it is this court's understanding that you are going to plead guilty to 2 misdemeanor charges. Is that your understanding?
Yes, sir, it is.
All right. First of all, that you're going to be pleading guilty to the charge of reckless driving. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
The other charge is an added count 4 of use of a Schedule 1 narcotic. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, Your Honor.
All right. Understanding all of that, do you still wish to plead guilty?
I do.
To the charge of reckless driving, how do you plead?
Guilty.
To the charge of use of a Schedule 1 narcotic, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, I do.
All right. You gave permission or did sign an advice of rights form, is that correct?
Yes, Your Honor.
All right. You have any questions regarding any of the rights that were explained to you?
I do not.
You understand, sir, that by entering this plea, you're waiving all of your trial rights?
I do. Yes, sir.
All right. You understand also, sir, you're giving up your right to appeal of right.
I do. Yes, Your Honor.
Are you on probation or parole? You are not.
I am not. I'm currently incarcerated in the Federal Bureau of Prisons.
Thank you, sir. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
Absolutely not.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes,
And because you believe that you're guilty of these offenses?
that's correct.
December 24, 2020, at the location of Michigan Avenue near I-94, Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Did you operate, how were you operating that motor vehicle that makes you think that you were driving recklessly, sir?
I believe the conditions of the road, it was winter time, and I was speeding.
You were driving too fast for the conditions?
Yes, sir. I'm not aware of the speed I was actually going, but I believe too fast for the conditions. That's correct.
All right. And you would admit that you were driving in a willful or wanton fashion with disregard for the safety of any other persons or property. Is that correct?
Yes, Your Honor.
All right. And on that same date, had you used fentanyl?
No, I don't believe I had use on that day.
Hey, were you in possession of fentanyl?
Yeah, I was in possession of pills, Your Honor. Yes.
You were in possession of pills?
Yes, Your Honor.
What kind of pills were you in possession of?
To my knowledge, they were Percocet.
They were Percocet? Schedule
Yes,
one.
sir.
All right. And you didn't have authority or a prescription to have those pills, did you, sir?
No, sir.
And you knew that you had them?
Yes, indeed, I did.
All right. Accepting the higher charge for the added count 4. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to counts 2 and 4. Counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14 probation. Sentencing in this matter will be March 13th, 2025, 10 a.m. Judge Washington.
March 13th. Okay,
Yes, sir.
just one moment. March 13th at, what time did you say? I apologize.
It's at 10 a.m.
10 a.m. Okay.
Yes,
Your
they'll
Honor-
have to do a writ to get you on Zoom, much like, or get you logged in, so that date might change a little bit.
And Your Honor, if I may, I believe Mr. Kukola has a number of other matters before the 14B court. And I did inform him that once that court knows of this sentencing, they should pull his other cases so that he can schedule and get those cleared.
Got it.
Yes,
Okay,
and
very good.
just-
Thank you.
If I could please add one thing, I know I'm in open court. I also have a charge in 15th District. Being in the FBOP, it's really hard to relay these things. So will that be addressed then as well? And the only thing secondly is, could you guys fax over to my counselor any court dates or any outcome of this so that they're aware of what's
your counsel may be able to find other court dates. I don't have the 15th District Court files here.
Okay.
I will email the Bureau of Prisons, Mr. Kukola, with regard to your sentencing on this, and I will contact my office to see if there is any scheduled date for you out of the 15th.
Thank you so much. I really appreciate
problem.
that. All right. You guys have a great day.
Thank you.
Thank you, Your Honor.
Court calls the case, People versus Demetrius Estelle.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Estelle. Will you state your name for the record?
Demetrius Estelle.
Thank
Your Honor, we're asking that this matter be set for a preliminary exam.
And discovery is complete.
To our knowledge, yes.
And will the people have their witnesses available the 25th?
We'll do our best.
Preliminary exam in person will be set February 25th, 2025, 9 a.m. That will be before Judge Barr. Bond will continue.
Thank you.
Thank you.
Thanks, good.
Court does call the case, People versus Amanda Absher.
Ashley Lonnie for the people.
Defendant fellow Nicholas Buckovich on behalf of Ms. Absher, who's speaking via Zoom.
Ms. Absher? Is she there? Not here.
Your Honor, I did try to get in contact with Ms. Absher via phone and email and have been unable to reach out. I consider she had a court date yesterday in 15th, and there may have been indication that she may be currently in treatment. However, I was not unable to get confirmation before today's court date, so I will be asking for an adjournment. She obviously did request a Zoom hearing with her counsel at arraignment. She did intend to be here today.
Okay. Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of 10,000 cash surety. That warrant will issue immediately.
Hello? Hello?
Hello? Hello, who are you?
It was not you, Ms. Cash.
Okay, Tom.
You're Ms. Kasham. We didn't call your case, but hello.
If you want to.
Court recalls case of the People versus Hirsch.
Ashley Lonnie for the people.
Public defendant fellow Nicholas Buckovich on behalf of Mr. Hurst.
Mr. Hurst, can you state your name, please, again, sir?
Mason James Hurst.
All right. Court is in receipt of the report and has reviewed same. Any additional evidence from defense?
No additional evidence, Your Honor. We stipulate to the findings in the report.
There's nothing from the people, Your Honor, either. We would stipulate to the findings in the report and ask the court enter an order. Independent competent stand trial at this time.
Court, after a review of that report, would find that based on that evidence, that the defendant is competent to stand trial. Specifically, that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I've signed the order. What do you wish this set for?
I was able to discuss matters with my client yesterday via Zoom, and he would like to set this matter for a preliminary exam. To my knowledge, we do have all media.
People have their witnesses. That's going to be a problem because they've probably been waiting. So go ahead, Miss.
Yes, Your Honor. Because the defendant is at the Wayne County Jail, I would request at least 3 weeks so we can do an in-person transportation for it.
Well, how do we do this? I'll set preliminary examination in this matter in person. That will be March 11th before Judge Washington.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Continue. Court calls case People versus Cody Lee Jolly. He's in Zoom.
Andrew Childers appearing on behalf of the people.
Mr. Jolly, can you acknowledge that you're there, sir?
Jolly. Time for court. Jolly. Hey, Jolly, it's time for court. Mr. Jolly.
Okay, he is present. I do see him. This is on the findings. So I'm going to assume there is no other additional evidence from defense. Is there any additional evidence from the people?
I have nothing on behalf of the people, Your Honor.
All right. Based upon the report submitted to the court will find that the defendant is competent to stand trial, specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. What I will do is I will adjourn this out for a probable cause conference. Mr. Jolly, do you wish to be represented by an attorney?
Jolly, can you hear the judge talking to you?
I'm sorry? He's not acknowledging anything. What I will do at this point is I will just set this for a probable cause conference. I'll set it for March 6th, 2025, 9 a.m. I will at that time advise him of the perils of self-representation. I won't do it today, so I'm not acknowledging court. All right, thank you.
Thank you, Your Honor.
Court does call the case People versus Darrell Hicks. Or Darrell Hicks.
Good morning, Your Honor. Any for the people? Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Hicks.
Your name, sir?
Darrell Hicks.
Thank you.
Your Honor, we're just waiting on some continued discovery. Received an email yesterday that it's en route, so it's going to be the last adjournment.
Probable cause conference, February 27th, 2025, 9 a.m. Bond continued.
Thank you. Thank you, Your Honor.
Thank you. Court calls case People versus, is it Cameron Brown?
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Brown. Mr. Brown, please state your name.
Cameron Brown.
Your Honor, we're asking for an adjournment. Ms. Curry is going to speak to the complainant in this case about a potential resolution.
You believe it? Okay. Probable cause conference, March 6th, 2025, 9 a.m. bond continued.
Thank you.
Thank you. Thank you, sir. So did you talk to her about moving furniture? Yeah, Maggie. Oh, well, now she just started picking up furniture and moving it around the corner. She didn't ask anybody. She just, like it was her house, redecorating. Huh? You didn't see it?
I'll take that.
Oh, you told her to get away from you, take the chair? Is that what happened? Okay, all right, I get it. Okay. Court calls the case, People versus Christopher Miller. Get away from me and take your chair with you.
Andrew Cho is appearing on behalf of the people.
Good morning, Your Honor. Edward Dukas on behalf of Christopher Miller.
Your name, sir?
Christopher Miller, sir.
Thank you. You're requesting an adjournment.
Yes, I'm looking to obtain the video, and I've spoken to the prosecutor about it.
Not objection, probable cause conference will be adjourned to February 27th, 2025, 9 a.m. bond continued.
May I say one thing, sir?
Okay, go ahead.
Your Honor, you would like to address bond just briefly.
Oh, okay, go ahead.
I'm sorry. I'm gonna say this myself, sir. So I did mess up, sir. I was nervous about going to jail, and I did mess up and take a shot, and I would say that. But I did have a lot to think about while I was in here last, on account of.
Did you?
Yes, because what had happened was something happened to my wife while I was in there. She had a miscarriage, and I wasn't even able to be there for her while she was in there. So that kind of like really sunk in that I messed up this time, especially after you gave me a chance, sir. So I was just trying to see if I could possibly get a new on or try a chance to show you.
Mr. Miller, so that we're clear, Mr. Dirk has made a very eloquent argument for you. It would be typically something where I would have blocked you off. I got sort of wooed by Mr. Durkis. I let you go, told you needed to go over and to test.
Yes, sir.
Sitting in my chambers. Wasn't 20 minutes. You went over and you blew numbers. If I had done what I normally did, we would probably not known that you had been drinking, but I did.
Yes, sir. I understand. Like I said, I've just really been trying to take care of this situation. That's why I turned myself in on it. Like, this is something that I wanted to address because I do have a good job, sir, and I was trying to get everything taken care of. And I promise you would give me another chance.
Twice. I gave you a break the first time. You messed that up. You were standing before me after having drank. I let you go over. You tested positive. I'm not changing your bond.
Yes, sir.
Thank you.
Thank you.
That is why Drukas wasn't speaking. There was nothing to say. Court does call the case. People versus Ernesto. We got Alvarez. Two cases.
Ashley Lonnie for the people in the armed robbery matter.
Big County for the people. 6-5.
Public Defender Fellow Nicholas Vukovich on behalf of Mr. Alvarez in both matters.
Okay, what are we doing?
From my understanding, yesterday when speaking to Mr. Alvarez, he was interested in waiving his PE. I do have a PE waiver form here.
He's going to waive on both cases?
On both cases.
Is that correct, sir?
Talking to you.
Yes.
You're waiving your right to preliminary examination in both of these matters?
Yes.
Okay. You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived. Defendant is bound over to circuit court in the case ending in 0065 on counts 1 and 2. And in the other matter on all 3 counts, I think, yes, on all 3 counts. Counsel?
Yes, Mr. Alvarez, may I sign the waiver form with your permission?
Yes.
And we'll be standing mute and waiving the reading of formal charges, Your Honor.
Defendant having waived formal reading, standing mute to all 5 counts. Court will enter a not guilty plea. Pretrial in these matters will be set for
February 26th at 1:30 before Judge Conlon.
February 26, 2025, 1:30, Judge Conlon.
And may I oppose to the sentencing waiver, Your Honor?
Yes.
Thank you, sir.
Thank you, sir. Court calls case People versus Dejan Ryan.
Andrew Childers appearing on behalf of the people.
Good morning, I'm Rob Chico on behalf of Mr. Ryan. Ashton, would you state your name for the record?
Ashton.
Judge, can we set this for exam?
All discoveries complete.
Yes, Your Honor.
People have their witnesses available the 25th. Childers, you were muted probably, sir.
Sorry, Your Honor. Yes, that's fine. Thank you.
All right. Preliminary examination in person will be February 25th, 2025, 9 a.m. before me. Bond will continue at this time.
Huh?
Thank you.
Yeah, hey, Drew, I'm gonna give you a call later on, okay? Thanks,
Court-
Judge.
Thank you. Court calls the case People versus Shauna Colson. Colston.
Alexander on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Colston. Ms. Colston, please state your name for the record.
Donna Colston.
Okay, Samson.
Your Honor, we're asking to set this for a preliminary examination.
Discovery complete.
I believe so, yes, Your Honor.
Do people have their witnesses available the 25th?
We'll do our best, Your Honor.
All right. Preliminary examination will be set in person, February 25th, 2025, 9 a.m. That's before Judge Barr. Before Judge Barr. Bond continue.
Thank you, Your Honor.
Court calls case People versus Joel Helm Mormon.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Hope. Your Honor, there is video outstanding in this case still. We requested it earlier this week. I believe it should be sent over to our office, but we just need a brief adjournment for that reason.
Probable cause conference will be adjourned February 27th, 2025, 9 a.m. Bond continues.
Thank you.
Case People versus Jeremy Davis.
Ready, Judge?
Alexander on behalf of.
Oh, you were gonna do something. No, I didn't know. I didn't know. No, I just thought you came in here trying to look pretty. I didn't know.
Thank you for noticing. Happy Valentine's Day. Early.
Your name, sir?
Jeremy Davis. Hands out your pocket. Torshell Feaster, Assistant Public Defender on behalf of Mr. Davis. Thank you, Judge. I have spoken to my client and to the people. This is the first PCC in this matter. If we could adjourn this so that we can have further discussions and try to see if we can reach a resolution, get an offer in this case, Judge.
Probable cause conference without objection will be adjourned March 6, 2025, 9 a.m.
Thank you so much, Judge.
Thank you. Bond continue.
All right, be back up here.
Court does call the case People versus Dante Powell.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Powell.
Your name?
Deontay Paul.
All right. What are we doing?
Your Honor, we're requesting an exam date. I have all discovery.
People have their witnesses available on the 25th.
I'm not available on the 25th unless it's in the afternoon, Judge.
Now, you know, you've been here. You said everything in the morning.
Okay.
So would the March 4th work then?
I have a jury trial that starts March 3rd. I have a jury trial that starts March 10th for the same individual. He has similar type cases. I did put in my calendar that I was available March 18th.
March 18th? Any objection from the people on that day?
Thank you.
Preliminary examination in person. We set March 18th, 2025, 9 a.m. That is before Judge Barr.
You said Barn?
Barr. B-A-R-R.
Okay, thank you, Judge. My client does want me to address the current bond.
Okay. Go ahead.
Judge, we were asking for a 10% option. I believe that the court has cash or surety, no 10% option. My client's mom is here and other members of his family, Judge. He will be with his mom, Judge. I know that I anticipate that the prosecutor is going to talk about perhaps a prior case, but I don't believe he'll be in contact with a complaining witness. Thank you.
Yeah. Response.
Your Honor, I do object to any change in the bond. Should have counted these up, but there are almost countless prior domestic violence charges, many of which were dismissed, but some of which resulted in to I appear to have been dismissed previously, to say nothing of other charges that are domestic violence adjacent that were also dismissed to include charges, things along those lines. Judge, I'll leave it at that. He's facing 2 felonies. He's obviously, in addition to all the DV counts that have previously been dismissed, at least 2 that he's convicted of giving rise to this felony. I'm unaware of any change in circumstances that would warrant any change in the bond. Stay as said.
At the time of this,
That's what we don't want to. We'll see. You're not getting.
he's got holds out of other courts, is what I see. He's got over 10 prior criminal convictions, 3 violent felony convictions, and 1 drug conviction amongst that. The other thing is, does he have an active PPO out of 22nd Circuit?
I'm not aware of
For
that,
this?
Judge. I don't know. The prosecutor might know.
That's the information that I have before me. But taking all of that into consideration, the motion for bond reduction in this case is denied. The court believes the bond is set as appropriate. Bond will continue.
Thank you, Judge.
Thank you.
Thank you, Judge.
Court calls case People versus Jacqueline Jones, Washington.
Assistant Public Defender Asli Bashir here on behalf of Ms. Jones, Washington.
Ms. Jones, Washington, can you state your name? There. What are we doing?
It has come to my attention that initially under a different name, and I did not see this initially, but there was a competency hearing on January 30th in cases 24F2-1087 and 24F2-1088. These are both felony cases that were before this court.
Before this court, when are they set?
There was a finding an order on competency, and Ms. Jones Washington was found incompetent but restored.
Okay.
Yeah, and so I would like to adjourn pending the treatment for that competency.
Well, was she under a different name or what?
Yeah, I think initially it was charged under Jacqueline. It's with a C in the name. I believe that's been changed in the court system now, but.
So when are those cases, if it's the same person, it's set, if she was found incompetent, it's set for a competency review. When is it set for a competency review?
May 1st, 2025.
So what do you want me to do with this one? Turn it out to that date? I mean, because I can't do anything, presumably.
Yeah.
I don't have a finding of competency in this case, but I could send it along with that case.
I believe, I'd be happy to file an order of competency or sorry, a motion for a competency evaluation, but I understand that the client has recently been evaluated. So
correct. All they do is send over the other report.
Yeah.
It would just attach to this file.
Okay. So I'll make sure to do that.
All right. So what I'll do then is I'll set it for probable cause because I would need to do that. You can send the order over anytime. I will sign it. I will set the probable cause for, what was her date? You said May 1st?
Yeah, May 1st, 2025.
I'll just set it for May 1st, 2025 at 9 a.m. Thank you. Thank you, ma'am. Court calls case People versus Buster Robbins.
Good morning, Your Honor. Tim Turkles on behalf of Mr. Robbins.
All right. Your name, sir?
Buster Robbins.
Thank you. What are we doing?
Your Honor, it's my understanding that the defense is wanting to schedule a preliminary exam in the matter.
All right. Counsel, is that correct?
That's correct, Your Honor.
All right. Is all discovery complete?
We believe so, Your Honor.
Your Honor, I was talking to defense counsel, and while there may be some stipulations that speed up the exam, this does have the potential, given the age of the case, to be a somewhat lengthy exam.
Oh, okay. Let's see. I'll let you try to coordinate. Will March 4th work?
Judge, the defense won't be available on March 4th. We were hoping for March 17th, the week of March 17th.
Pardon?
The defense won't be available that date. We were hoping for the week of March 17th.
Do you have any objection to the March 17th week?
If it's in the beginning half of the week, we should be okay.
That's fine, Judge.
I don't know what that means.
Our lab analyst is out starting the 21st. So if it's March 17th.
Oh, well, we'll set it for March 18th. Preliminary examination in person, March 18th, 2025, 9 a.m. in person before Judge Barr.
Thank you, Your Honor.
Thank you. Bond continued. Thank you, sir. Don't have the order. Who told you that?
Mr. Lauren Brown, but also.
Lauren
Mr.
Brown
Dukas
told you that?
And Mr.
He's not
Dukas.
trustworthy.
I know, but Mr. Dukas did.
Mr. Durkin said it? Okay, then we believe it.
Oh, okay.
Not right now. But I figured that's what they do. But. Court calls the case People versus Haley Gregg.
Assistant Public Defender Natalie Pate for Haley Gregg, who may be on Zoom. So, Your Honor, I did not have a good phone number. I did have an email address, which I did email but did not hear back. I do not have an explanation for the failure to appear. For the record, I would request an adjournment so I can try to get a good phone number for that.
How long will that take you?
I don't know.
Bench warrant will issue bond 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Court calls the case People versus Ashton Gregory.
And then on behalf of the people, Your Honor.
Good morning, I'm Rob J. Cool on behalf of Mr. Gregory. Ashton, would you state your name?
Ashton Grisham Gregory.
Judge, I'd like to set this for exam, please.
When was the last time he was here?
A couple weeks ago, right?
Does I have a conditional bond violation? Are either party aware of that?
Your Honor, I was already picked up the new case. 25.
Pardon?
He picked up a new case with the same victim.
Was that offense date on that 2/2/25? Do you know?
It was. You said 2/2/25, Your Honor?
Yes, the offense date. Yes. So that case is the bond violation in this case.
We set for exam on the 25th.
What's the status of his new case?
Perfect.
One moment, Your Honor, I'll pull it up. Have any updates on the next court date for that one, Your Honor? I believe he was arraigned.
Were you arraigned?
That's just the 25th.
Yeah, was he arraigned on the new case or was he arraigned on the bond violation
I think he was
for
arraigned
this case?
bond violation, but I don't know if he was arraigned on that case.
Wait, hold on.
Ashton Grisham Gregory was arraigned on a 14 misdemeanor on the 2nd. I'm sorry, on February 3rd.
Dixie Township?
Yes, sir.
Okay, so that one. Got it. Okay. People have their witnesses available the 25th.
We'll do our best, Your Honor.
Judge, may I make a quick bond motion?
Can I set a date?
Sure.
Preliminary examination in person, February 25th, 2025, 9 a.m. before me. As the bond.
But just real quick, this young man's probably had 3 to 4 epileptic fits at the jail. I don't think he's getting the proper medication. What I would ask, he does live with his mother. His mother has asked me if he could be released on a tether. She will, under home confinement, and she will make sure that she addresses.
If it's regarding medical treatment, I'm not, and historically, I've not gotten involved in that. You're gonna have to speak to the jail if you don't believe that he's being properly tended to. Because I don't know.
Judge, I'm not trying to disparage the jail. It's just that being in the jail is causing a lot of epileptic fits. I understand that sounds somewhat facetious, but that being said, Judge, he does have these medical needs that need to be addressed.
I may agree with you on that. What I'm indicating to you is I'm not going to address them. I don't have anything else in front of me other than these representations. And there is very fine medical staff and facilities at our Washington County Jail. So he needs to address those concerns there to them and see what they do.
All right, thank you.
Bond will continue. Thank you. Court does call the case, People versus Lynette Harrison.
Assistant Public Defender Jay Bellinger on behalf of Ms. Harrison, who approaches. Ms. Harrison.
Lynette Harrison.
Thank you.
And Your Honor, I just reached out to the prosecutor yesterday to see if there was any outstanding discovery on this. I'm seeking some additional, so I'm asking the court for an adjournment of a couple weeks so we can see if that exists.
March 6, 2025, 9 a.m. Bond continued.
Okay. Thank you. I'll see you. We'll give you a call.
Close case. Cases of the People versus Anthony Warren, 2 cases.
Only for people.
And good morning, Your Honor. Sydney Rushing on behalf of Mr. Warren.
Asli Bashir on behalf of Mr. Warren for the 4F4-1590 case.
Your name, sir?
Anthony Warren.
Okay. What are we doing?
Your Honor, on the 0128 form, I was just appointed at like 7:45 this morning, so we're seeking an
So you're
adjournment.
not ready?
We are not ready.
Okay.
And for the 1590 case, we are seeking to adjourn. I've inquired about potential outstanding discovery on this case, and I'm back or confirm.
All right. I'll adjourn both matters out to February 27th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right, thank you. Take that back.
Take it back.
Court calls case, People versus Ryan Piper.
Ready for the people? Public Defender Fellow Nicholas Bukovich for Mr. Piper.
Sir, your name?
Your name?
Ryan Pieper.
He's what are we doing?
At this time, Your Honor, we'll be requesting adjournment. We did receive an email from the Michigan Department of Health and Human Services, which I have forwarded over to APA Kennedy. This dates maybe about 4 more months until Mr. Piper gets a bad foot treatment for restoration for competency. I do have a copy of the email I can also provide to the court as well.
Well, hold on, counsel. All right, so we set it for today, but
Yes, however,
I just have the order. I'll sign the order. I'll set a competency review hearing then for May 15th, 2025, 9 a.m.
Yeah, and my client would like me to address bond if possible.
Pardon?
May I address bond if possible?
Go ahead.
Due to the nature that Mr. Piper will have to wait for over approximately 4 months to obtain treatment, I'll be requesting a possible release. He now has family who reside in Canton, Michigan. So I'll be requesting a possible release on tether or any alternative of reduction in his bond due to the fact he has to wait for the treatment in over 4 months.
Is there any response from the people?
No, I would leave to discretion.
I'm not going to release him. I looking at everything. I'm not going to release him on a tether. He's here on a criminal sexual conduct charge, and without some structure in terms of his release, I'm not just blanket releasing him on a tether.
Okay, understood, Your Honor.
So motion for bond reduction. Court calls case People versus Justin White.
Please, the court, George Lyons appearing on behalf of Mr. White. Mr. White is incarcerated. I don't see him on the screen.
Mr. White, you don't see him on the screen?
I know
we'll
that.
Have him say something. He'll come to the screen. Your name?
White. Justin?
You see him now?
I do.
All right.
If you give me a moment to wipe the egg off my face, Your Honor.
Pardon?
Give me a moment to wipe the egg off my face.
Oh, no, it's okay. Okay, we're all with you. All right. What are we doing on this case?
Your Honor, we're going to set the matter for preliminary examination, and I'd like to address the issue of bond as well.
All right. All discovery is complete to your knowledge, sir?
As far as I know, Judge, yes.
All right. People have their witnesses available the 25th?
Do our best, Your Honor. And for the record, Katie is most people.
Preliminary examination in this matter will be set in person February 25th, 2025, 9 a.m. before Judge Barr.
Your Honor, if I may address bond?
Pardon?
May I address bond, Judge?
Sure.
And not be brief. My client presents with no juvenile record, no adult record, been in jail for approximately 30 days. If he's allowed to post bond, he'll be moving to beautiful downtown Atlanta, Michigan, which should be punishment enough, Your Honor, with his mom. He has no contact, no reason to be in Washtenaw County other than this matter. Even to visit counsel would be in Jackson, Michigan. Respectfully, his bond is $50,000 cash surety. I'm asking for a $10,000 either unsecured or 10% bond.
Response.
I guess what concerns me most in the moment are some summaries of some jail phone calls I have received just this morning. I do not have any information about any direct contact between the defendant and the victim, but I do have a summary of several phone calls wherein there are communications between the defendant and someone, seemingly a friend named Joe, and then also family members talking about asking them to make connections with the victim. Either tell her I love her or tell her lots of bad words, we need to drop this case, so on and so forth. That is what concerns me most in the movement.
Better. And you, I'm sure, have not, at this point, counsel, you don't have those. But
no, Your Honor, I just spoke to my client yesterday, and this is news to me.
Yes. So with that information, at this point, I'm going to deny the motion for any bond reduction in this case. Have you listened thoroughly to it seems what you're indicating to the court is that there are these third-party contacts attempting to get to the victim.
Yes, Your Honor. I have not personally listened to the phone calls. What I am doing is reading a summary that is put together appears to be some direct quotes from certain phone calls that is put together by an intern from our office.
Okay, pending a hearing on this, defendant's phone privileges are hereby ordered revoked.
Thank you, Your Honor.
Judge. Judge Ball, Your Honor.
Pardon?
And Judge Ball.
Barr, B-A-R-R.
Thank you, Your Honor.
All right, thank you.
Thank you, Judge.
Court calls case People versus Robert Jones.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Jones. I had to remember what time it was. Mr. Jones should be on Zoom. He was having trouble with the app this morning. I did provide him with the call-in number.
Yes, I'm here.
So that might be
Can you hear me?
him.
Yeah, can you hear me?
What's your name?
Robert Jones.
All right, he's here.
Your Honor, we're requesting.
Because I wasn't believing you at all. But go ahead. So I'm shocked.
I believed in him. We are requesting an exam, Your Honor. The one caveat is that there are medical records that the complainant made a mention to when reporting this alleged incident to the officer. Myself and Ms. Senda have been in touch with them. We don't have them. She's followed up with the officer. I informed my client of that. He still wants this exam to be set. So that's what we're asking for, with the understanding that an adjournment will not happen if we don't have them.
And that's correct, Your Honor. I've reached out to the officer. He reached out to the victim, hasn't heard back, so we do not have those yet. Waiting on.
He understands though that if those medicals aren't here, that it's not going to be adjourned.
He understands that.
People have their witnesses available the 25th.
We'll do our best, Your Honor.
Preliminary examination. In person, February 25th, 2025, 9 a.m. before me.
Your Honor, may I just forward here my client to make sure he understands
Understands what?
that he's not going to have an adjournment if we don't have those medical
You already
records.
told him.
I did, but I just want that placed on the record, Your Honor. Mr. Jones, I know we spoke about this. You understand we won't have an adjournment if we don't have those medical records?
Yes, yes, I do.
And you'd understand we'd be going forward without those medical records if we don't obtain them on that date?
Yes.
Satisfied, Your Honor.
I'm continuing.
Thank you.
We'll see you on the 25th. Court calls the case, People versus Joseph Pinkston.
Ashley Londy for the people in both matters.
So hold on. Schnaza hasn't had a case today. Like all in here. Did you see that? I just no. I was just noticing it. Do you have any cases, Schnaza?
Yes, Your Honor, I do.
Okay, we'll wait.
Sorry, Your Honor. Assistant Public Defender Natalie Tate on behalf of who is to my right. Is it okay if you remain seated, Your Honor? He's in the wheelchair.
Yes.
Thank you, Your Honor. Mr. Pinkston, can you please state your name for the record? Thank you, Your Honor. I have discussed this matter as well as Mr. Pinkston, and he does wish to waive his right to a preliminary examination in both cases. He did just give me permission to sign the waiver form on his behalf.
And that's my understanding as well, Your Honor. There was an offer extended by my office, which would need to be taken advantage of in time. It's not available down here. Basically, it will be to plea discharge to 25F55019, which is controlled substance possession of methamphetamine, and in 24F41077 to plead to count 2, possession of fentanyl, and dismiss count 1, possession of methamphetamine. And that is based upon the waiver of this examination. There are other agreements or offers.
That is my understanding as well, Your Honor.
Sir, You're waiving you're waiving your right to preliminary examination?
Yes, I am.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
All right, people for the record also waive their right.
Yes, Your Honor, we do.
Preliminary examination having been waived, defendants bound over to circuit court on all three counts.
Thank you, Your Honor. We acknowledge receipt of the information waived for the reading and my client stands mute.
And then having waived forward reading, standing mute to all charges, court will enter a not guilty plea. Pretrial will be set for February 24th, 2025, 1:30. Judge Hamud.
Your Honor, may I make a brief request as to bond?
Yes, you may.
Thank you, Your Honor. Since coming into custody, very unfortunately, Mr. Pinkston has had to have emergency gallbladder surgery. It is my understanding that that took place this past weekend. He was taken to the hospital, then of course brought back to the jail. Since I've been meeting with him, I've personally seen a steep decline in his physical health. He is in severe pain. I have spoken to his mother who resides in Monroe with Mr. Pinkston's stepfather. He's asking that he be released on both cases on a PR bond. The only other thing holding him is a $100 bond on a DWLS out of 15th. We're asking that he be released today on a PR bond so that he can reside at home with his mother in Monroe while recovering from his surgery. These cases are nonviolent allegations. He has waived his right to a preliminary exam. We ask that he be released today on these matters.
Ms. Lundy.
If I recall correctly, I'm pulling up my notes now to double check, but the defendant was out on bench warrant status in the 24F4 matter for some months and only came back in to face these charges as a result of being picked up new possession of methamphetamine case, the 25 case, where he was, I believe, found slumped over, semi-conscious in a vehicle that was parked at a gas station, I believe. And then the drugs were found in his vehicle. So I am concerned that if he is released, he will not remain law-abiding.
Respond, Your Honor.
Sure.
He's in a wheelchair. He's in severe pain. He would be staying at his mom's house. I have zero reason to believe that he would commit any sort of failure to appear even or any bond violations of any kind. He would be more or less bedridden, staying with his mother. His mother is not a drug user and does not have drugs in the home. I would be asking that he be released so he can deal with these cases while recovering at home.
Motion for bond reduction is denied. Defendant, he picked up the new case while he was out on bench warrant status on this one, from my understanding.
I understand, Your Honor.
Thank you. Court calls case Pico versus Lumay Kappa.
Ashley Lonnie for the people. Kaba.
Women Kaba.
Okay.
Assistant Public Defender Natalie Patewith, and on behalf of Mr. Kaba, who should be present via Zoom. Sir, can you please unmute and state your name for the record?
Lamine Kaba.
And that's on count 3.
Yes, sir.
All right.
And Your Honor, it sounds like the court was just looking at the amended complaint. There is an added count 3 of attempted disarming a peace officer that has been charged by my office. I'm not clear on whether the court needs that to be sworn out or not, so I just wanted to ask for the court.
I don't think I need it re-sworn out. I just need, it's an amended complaint. Are you going to waive any further reading of?
Yes, Your Honor. We would waive any further reading of that. My client stands mute.
All right.
Thank you, Your Honor.
Will indicate the defendant has been arraigned on count 3 and has stood mute to that charge. All right. What are we doing with the case?
Thank you, Your Honor. I'm respectfully requesting an adjournment so I can speak to Mr. Kaba. We've been playing very active phone tag, so we just need to have a meaningful conversation about his case.
Probable cause conference, March 6, 2025.
Thank you, Your Honor.
9 a.m. Bond continued. Thank you.
Thank you, Mr. Kaba. We'll talk.
Ms. Pate and Ms. Lund, can you approach this?
Yes, Your Honor.
Good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Williams. Please state your name for the record.
Jeffrey Leon Williams. Thank you.
Your Honor, in this matter, we are seeking a brief adjournment to receive and review discovery.
Is this the only thing holding him? Or
I'm sorry, Your
is
Honor.
this the only thing holding him?
Yes, Your Honor.
All right.
And we would like to briefly address bond.
I know you would. Probable cause conference will be adjourned out February 27th, 2025, 9 a.m. All right, Esteban.
Your Honor, Esteban, Mr. Williams was picked up yesterday on a tether violation. His tether died. He did have a $10,000 personal bond prior to that. I spoke with my client about that. His tether needs a new cord. So I think as long as we get a new cord, like a charging cord. So I think as long as he can get that.
Seriously?
Yes, Judge.
That's all it was, Your Honor. I just needed the cord, and I bought a friend, and then we got mad, took it back or something. It was crazy. It happened, and it started beeping. And I said, I was so tired.
Hold on a moment. So where's the cord?
The friend, the guy that I got confused between the two, which cord was which. One was damaged, one wasn't. And so it was confused between the two, which cord was one. I didn't want to get into a whole, you know.
Hold on a second. Is the cord, did the cord go back to community corrections?
I could refund it as soon as possible. I could pay for it, sir. But I don't know. I don't know where it went to. I fell asleep and woke up and it was gone. You know what I mean? Certain different things. I'm not sure what happened to it.
Was this at the homeless shelter?
Yeah, it was at the shelter. So I stayed at the shelter. So, you know what I mean? I just woke up and my stuff was scrambled through. And I'm like, man, is that my cord? He's like, no, it's not. This is my cord. So I just left it alone. You know, you can't something like that.
Did you do that? Because
it was one or 2 days, like 1.5 days I had the cord.
Well, if the guy took your cord, why didn't you call community corrections? Tell him that other guy's got my cord. I need a new one.
You didn't think to do that?
I was about to, but I didn't get around to it in time. They called me before I could get up there.
I don't need a response. Motion for bond reduction denied. Bond will continue.
Thank you so much, Your Honor.
What is that?
He said it's-
Oh,
Thank you, Your Honor.
yes. Thank you. He's not an expert. It sounds like a story I had with my phone charger. I woke up, somebody took my charger. Rushing. Did you think that was gonna work? No, don't even answer. No, I'm just asking.
Your Honor, they have some experiences that happened to them.
No, I agree. I agree. Court calls the case, People versus Darnell Slayton. Oh.
Clayton?
Go get up and do some work today. Okay, go ahead.
Assistant Public Defender Chinaza Ikeri Akinruli, Your Honor, on behalf of Mr. Darnell Slayton, who is approaching.
No, he's not. Why are you looking that way?
Hey,
Right.
oh, he's there. Mr. Slayton, could you state your name for the record, please?
Darnell Slayton.
Your Honor, we would like to set
I
this.
should have just sit there.
Keep
and stare
looking
at
that way.
door.
They opened the doors. I knew somebody was coming out. We'd like to set this matter for preliminary examination, Your Honor. My understanding is that discovery is complete.
People have their witnesses available the 25th.
And Your Honor, if I could address bond just very briefly.
Preliminary examination in person, February 25th, 2025, 9 a.m. before Judge Barr. Yes, that's the bond.
As to bond, Your Honor, we are asking that the court consider a personal recognizance bond in this matter. Mr. Slayton, when he was arraigned, he did have a violation of probation out of circuit court where he had a bond denied. So this bond is currently set at, I think it's $500. We were able to get that bond reduced to a PR bond yesterday in circuit court. So we're asking that this court allow him to be released on this case as well.
Response?
Judge, I think he's a danger. I object to any corruption. I feel it's a fairly nominal bond at this point. I understand. We're not necessarily talking about, forgive me. I'm mixing up files. He's got a prior armed robbery conviction, unarmed robbery conviction. Looks like from 2019. I am aware of him at least reporting to the victim in this matter having shot at her before. That case having not proceeded, that May 1, 2021, that was dismissed by the court for her failure to follow through. That was also an A1 charge of GBH charge at FH. A discharge in the building. There's another letter that was dismissed by the court in 2019. Judge, I have serious safety concerns.
Anything else?
Nothing else, Your Honor.
Motion for bond reduction denied, bond will continue.
Thank you, Judge.
Let's call the case, People versus James. Is it Valkapour?
Yes, ready, Judge. Good morning, Your Honor. Marie Tanhoff, Assistant Prosecuting Attorney on behalf of the people.
And good morning, Your Honor. May it please this most honorable court, Nicole Casca. I am co-counsel with Scott Weinberg on behalf of Mr. Valkapour. Mr. Valkapour is in the jail. Can you please state your full name for the record? Nice and loud.
James Daniel Valkapour.
Okay. And you're requesting an adjournment.
Yes, Judge. It has come to our attention that after discussions with the detective on the case, that there is video discovery that's outstanding. I believe the people have not even seen it yet, nor do they have it in their possession. So we do need that in order to have discovery complete.
Your Honor, to clarify, I did speak to counsel this morning. There is video that normally would go out in our usual way through evidence.com. We suspect that there may have been some of the CSAM uploaded, hopefully not, but we want to make sure that's not the case. So I'm looking into that. And once I have confirmation that there's no CSAM part of that material, we'll make sure that counsel gets that discovered.
All right. Couple weeks or?
At least a couple of weeks, please.
At least a couple of weeks. Is this the only thing holding him?
Yes.
I believe so, Your Honor.
Yes, Judge. He has no other contacts. He's not on probation or parole to anyone. He's got no criminal contact. His parents are in the audience. They've been here all morning since 9 o'clock.
Well, so have I.
Yes, you have, Judge.
Okay, so I don't know what that
Your Honor,
means to me.
may I, since we're talking about moving towards talking about bond.
Yes, go ahead.
Your Honor, I did receive the motion. I believe it was yesterday. So I haven't filed a written response. But if the court would like me to address it, I can.
Yes, you can.
Your Honor, I was at defendant's arraignment. This is a very concerning case. I will agree that there's no criminal history that we know of. However, I think as we all know, I don't think you escalate to this type of behavior just kind of overnight. To give some additional background that's not necessarily in all the paperwork, this is a matter where not only was there CSAM, and when I'm saying CSAM, we're talking about children involved as young as 18 to 24 months estimated on videos that are associated with this defendant with his account. We're not claiming that he did the videos, but there are certainly adult males who are doing things to 18 to 24-month-old children that he apparently has an interest in viewing and saving, and there are multiple videos associated with his account. In addition to the CSAM that was found, and I don't think it's necessary for me to go into the specifics of those, in addition to that, he's been in communication with an underage minor who is out of this country, not in this country,
That communication is not only of a romantic nature, if you want to call it that, but also of a sexual one, to the point where he sent nude pictures of himself to this minor, asked her to send nude pictures of herself, talked about masturbating to the thoughts of this minor. She reminds him that she is a minor, she's 13 years old, that this is not okay. She broke up with him, again, if you want to call it that, try to end all of this. He threatened to expose her. I'm not sure exactly what, but he mentions a selfie that he would expose. Make sure essentially submit to him completely, say certain things, do certain things, or he will expose her. She keeps asking him to stop. I think at some point there's talk about the legality of things. He says, it's not illegal because I'm not doing anything to you sexually. He also says something to the effect of, I'm not going to get in trouble, and you don't have the balls to get me in trouble. Unfortunately for him, I do have balls to get him in trouble. That is not acceptable. We are not going to stand for that. I think the bond is more than appropriate in this case. I have grave concerns that not only was this CSAM, it escalated to these interactions with a minor who luckily was not physically in his presence. I have very little doubt that he would escalate to physical contact if he was given the opportunity to do so.
Judge, if I may.
Yes, please.
Thank you. Judge, my client is 20. He is a junior at University of Michigan. He was doing extremely well. He was arrested, I believe, either on the 3rd of February or the 4th on campus in front of his fellow peers. Judge, with regards to those allegations, what was not relayed to the court is that this came from a tipster from the state of Minnesota who goes and gives information about something happening on the same Discord, this is going on the Discord app that he was on, and in those same chat rooms. And the issue is that we do not have, I think the people are going to have some issues proving that, one, this person in Germany or wherever they are allegedly is in fact a real person, and they're not, and that they are a minor. Second, we have, these are allegations. I know they're very serious allegations. My client understands that, so does his family. That being said, he is not a flight risk. We're asking the court, the bond is currently set at $250,000 cash. We're asking for something.
I'm trying to figure out if half of what the prosecutor is saying, why it's set so low, quite frankly. But you can go on.
Thank you, Judge. Judge, we are requesting a lower bond in this amount, 10%, so that family can post. They are here. They have no issues, and they do plan on going to court with him for all court dates, for any other evaluations or anything else that needs to be done on this case, making all appointments. He's not a flight risk. Judge, we're asking for something lower so that we can be able to go and get him out, so that maybe he can in fact finish the semester that he has online with U of M. He has no prior criminal record, Judge, no juvenile adjudications, nothing of anything of this nature, anything assaultive. But these are allegations at the end of the day.
Well, yeah, but very serious ones.
Of course. And I know this court takes it very seriously, as do we. But we're also asking for justice to also be administered in a way so that Mr. Valkafor can have an opportunity to be able to defend against these charges with his counsel.
Anything else? Motion for bond reduction. I won't raise it. I'll leave it where it is. I'm not going to reduce it, given the nature of the allegations as well as what I see here. So motion for bond reduction tonight. His bond will continue. I'll adjourn the probable cause conference. I'll go out to the 6th, and hopefully they can get all of that to you by that time.
Thank you.
March 6th, Judge?
Yes, March 6th, 9 a.m.
Thank you, Judge.
Thank you.
Thank you, Dr.
Court calls case People versus Amal Kasham. She was here.
She's been in and out. Yeah.
But be agreed on behalf of people.
Assistant Public Defender Natalie Pate on behalf of Ms. Kasham, who should be back in the Zoom.
Ms. Kasham? She's bumping in.
Yes. Your Honor, I do know she was on here earlier, and then I got a message from Mr. Paul Ward that she had logged into Magistrate Fink's Zoom, but then I was texting with Ms. Kasham and she was going to be returning to your Zoom. And
I have the name, I just don't, no response from her.
I will state briefly for the record, Your Honor, she was texting both me and someone else in my office this morning that she has been sick, and so she might, there she is.
There
Good.
she is. Ms. Kasham, you there?
Hello?
Hello, state your name.
Hi. Hello?
Hello.
Hi.
Okay, that is Ms. Kasham.
Yes, it is Ms. Kasham, yes. Your Honor,
I'm sorry,
we're
I'm not
respectfully
feeling
requesting.
too good.
It's okay.
Your Honor, I'm respectfully requesting an adjournment. Ms. Kasham and I are going to be meeting in person tomorrow to discuss her case in detail and get potentially a document from her that I believe I'd like to
I'll
provide.
adjourn this to March 6, 2025, 9 a.m. All right, bond will continue. Feel better, Ms. Kasham.
Thank you very much, Your Honor.
Thank you.
Kasham.
Court calls case People versus D'Angelo Simmons.
The judge.
Oh, he's gonna do something else today. All right.
Torshell Feaster, Assistant Public Defender on behalf of Mr. Simmons. Please state your name for the record, sir.
D'Angelo Simmons.
Thank you, Judge. My understanding is in this case, waiting for a bed for Mr. Simmons to try to get him into a facility. I believe he was determined incompetent but restorable.
Yes.
He has not yet been sent away. I am trying to help find a way to get him out of here as soon as possible. I guess we need weeks or so, and hopefully he'll be out of here before then, and we can adjourn that day.
Last time I adjourned it to this date, so we can. But I think that was the review. But
I understand.
if I set a review out, I don't know what's going to happen if he doesn't. He's not being treated.
Right.
At this point.
I'm open to suggestions, Judge. I don't know how to.
Well, I was going 30 days out, but I think this is a different kind of circumstance here.
Yes, Judge.
So what I will do, unless there's an objection, is put it out to my May date.
Okay.
If something comes back before then, we can of course set the hearing if necessary.
Sounds great, Judge.
So I set a competency review in this matter for May 15th, 2025 at 9.
And meanwhile, I'll try to help him find a bed, Judge. Thank you.
Enough. Thank you. Bond will continue.
Thank you.
Okay. But she left. She had a medical. All right. Court recalls the cases of the People versus Samantha Warren.
Good morning, Your Honor. Edward Drucas on behalf of Samantha Warren.
Okay.
Andrew Childers appearing on behalf of the people.
I have received the paperwork regarding the withdrawal of the PD and the appointment of Mr. Drucas to her other matters. I will sign those orders. We will leave the same date that we have. My understanding is Ms. Warren had to leave for a medical appointment, so I'll excuse her presence. And since it's the same kind of another case, I'm not worried that she.
Yeah, she's aware, and I discussed that with her as well as I assisted her with trying to get these to be arranged. So,
all right, very good.
I think it's to her benefit.
Okay, thank you. Court calls case People versus Zachary Capella. Is it Frangidakis?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. I believe it's Frangidakis.
Frangidakis.
Yes, who should be on Zoom.
What did I do with the other part? Okay.
Oh, you're
Sir,
muted, sir.
Can you unmute and state your name?
Zachary Frandakis.
Say it right either.
That was pretty close.
No, you didn't say right. Don't.
Oh, that was pretty close.
It looked like, oh, I got it right.
It's a good shot. Good
A lot
I
of
know
people
I didn't
butcher
get it
it.
right, but I know I didn't get it right, but you didn't get it right sitting there looking all smug. All right.
She was close.
See?
Oh, yes.
She
good
was
up for
close
her.
enough.
That's not going to be good for you. All right.
Not surprised.
All right.
Your Honor, we're asking for an adjournment. There was some discovery that was under a protective order that was signed yesterday, so we didn't chance to receive that and review.
All right. Very good. Why don't I go out to the 6th? Will that be enough time for you to?
It should be. Thank you.
All right. March 6th, 2025, 9 a.m. Bond continued.
Thank you.
All right. Thank you. Thank you, sir.
Thank you, Your Honor.
Court calls the case People versus Cynthia Solomon.
Good morning, Your Honor. Mary Tan, Assistant Prosecuting People.
Assistant Public Defender Jay Bellinger on behalf of Ms. Solomon, who approaches. Ms. Solomon.
Your name?
Cynthia Solomon.
All right.
Your Honor, we're here for PCC today. Okay.
No, go.
It's my understanding that Ms. Solomon is working with our AIM division. For that reason, I'm going to be requesting a 2-week adjournment. I believe they're putting together mitigation for her and helping her with programming. But I would like to address bond. I think that's the more important issue of today.
Okay. Do you need a 2-week adjournment?
I do.
Any objection to that? Probable cause conference, February 27th, 2025, 9 a.m. Yes,
Thank you.
Mr. Bond.
As to bond, Your Honor, my client's in a family way. She's 30 weeks pregnant.
I understood what you're.
I figured.
Go ahead.
She is 30 weeks pregnant, Your Honor. She's very high risk. She was given a prescription before she started this pregnancy, and that prescription has not been given to her in the jail. She has no prenatal care while in the jail. She's already had an incident where she's had to go to the hospital once while in custody. I am asking for her release. She advises that she can stay with her fiance. No one involved in this matter. I believe the complaining witness is a minor child that she has no contact with currently. And she has no contact with her mother either. I'm asking that she be released as she is 30 weeks pregnant, going on 31, obviously, and she's.
So the child that is the subject in 1006 is not her child.
It is my child.
It is, Your Honor.
I'm understanding it is her child. I believe the child is now with a different family member. And so that would be our biggest concern, is that make sure that there is no contact.
You have it.
Yeah. Well, who's the child with? Do we know?
My child's father, Your Honor.
That's our understanding, Your Honor, is that the child's with its father.
Was there anything else from the people?
No, Your Honor, I'll leave it to the court's discretion. I've been talking to Mr. Ballinger and one of his colleagues previously about resolving this case. Well, we want to see Ms. Solomon work on herself, and I think we can reach a resolution. I think she can be an excellent mother if she gets some things figured out.
Right. I'm looking at. Without saying the names on the record, I have 3 names listed on her bond form of no contact. Is one of those individuals child?
All 3 of them. All 3 of them are. All 3 of my children.
So they're all 3 your children that are
yes.
Your Honor, we had requested no contact with any minor. I don't know if that's going to be an issue, but that might be.
That will not be an issue.
Okay, for now.
That won't be an issue.
That will not be an issue, Your Honor. She advises that she can stay with her fiance. He lives in the city of Westland. She would not be in the vicinity of children.
Then let me ask this: is CPS currently involved?
Yes, Your Honor.
Okay.
I haven't had any contact with them since I've been in here. Besides to discuss whether or not they were going to do a mandatory custody petition.
I know that they are working eventually on reunification, Your Honor, but at this time she hasn't been.
That doesn't. Okay. All right, guys. All right. Since the no contacts are already in place and given what counsel's indicated, defense counsel's for I'm going to add a provision of no contact with any minor children. You understand that?
Yes, Your Honor.
I'll grant the reduction in bond. I'll set her bond.
Thank you.
I'll set her bond in the amount of $50,000 personal recognizance bond.
And Your Honor, if I may, my concern is that if she has the baby would be a minor child, obviously. Would she have permission to?
You are so bright.
It is a concern.
Your brilliance amazes me every week, Mr. Bellinger.
Just wanted to make sure that she'd be allowed to.
Okay, Mr. Bellinger, I hear you. Do you really think I would find a bond violation?
I don't, Your
Because
Honor.
she's in contact with.
I don't, Your Honor. But I just want.
So you're just going to talk about it.
You never know. You never know with these prosecutors, Your Honor.
A bunch of troublemakers up here. We like to do our job.
Yeah,
Too well sometimes.
Wow.
Too well.
Wow. Boy, that. I know. Just. Okay. Did you want me to make that exception?
Yes, Your Honor.
No, I'm not going to make it an exception. It's not going to be a bond violation.
Okay, thank you.
It's just not. I mean,
Thank you, Your Honor.
he almost blew it. I almost.
Hey, you know.
I almost said this is going to get too complicated. So
We got some overzealous people working here, Your Honor.
All right.
I do appreciate everything that you're doing, Your
No
Honor.
offense.
Take care. Good luck to you.
You too, thank you.
All right. We'll be in touch, okay?
What did they have this for?
You.
You.
See, I don't know why they did that on this case. All right. I think that does it. Because if the baby's born, that'll be a child. Brilliant. No, brilliant, brother. Courthouse case. People versus Natasha Lawson. The baby's gonna be a minor. No, it's gonna be a full-fledged adult.
Oh, great, I didn't hear. Ashley Lottie for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Miss Lawson. Will you please state your name for the record?
Natasha Lawson.
Thank you.
Your Honor, mitigation information was provided to the prosecutor. We're asking for adjournment for some negotiation.
Probable cause conference,
Oh, it shouldn't be.
March 6, 2025.
What's your legal? Okay.
Thank you.
Thank you, Your Honor.
All right. Thank you, Judge.
Court calls case People versus Michael Sterling or Strelling.
Hannah Mackey on behalf of Mr. Strelling, who's appearing to my right. Please state your name for the record.
Michael Straley.
At this time, we would ask for a 2-week adjournment.
Probable cause conference will be adjourned February 27th, 2025, 9 a.m. Bounds continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Eric Mayfield.
Andrew Childers appearing on behalf of the people.
Ashley Moan, Assistant Public Defender, appearing on behalf of Mr. Mayfield. We are requesting a preliminary exam, please.
Discovery is complete. No.
My understanding, yes.
People have their witnesses available the 25th.
That's fine, Your Honor.
Preliminary examination in person, February 25th, 2025, 9 a.m. That is before me. Bond continue.
Thank you.
Courthouse case people versus Alton Ford.
Ashley Lonnie for the people.
Appearance was filed by an attorney, but it doesn't say which attorney. I don't have
What do you
the
mean?
here. JS just an attorney appearance was filed, but there's not an appearance, and I don't see one in there. So it might still be in the clerk's office.
Can you call
Yeah.
your name, sir?
Alton Ford.
All right. Are you represented by an attorney?
Yes.
Quentin Dox.
Quentin Dox.
Filed an appearance. Have you had any contact with them between the last?
I talked to him
before
Saturday.
This hearing?
I talked to him Saturday. He was in the jail.
Okay, did he know about today?
He looked it up on his computer and he couldn't find a date, but I told him it was for the day I have an evidentiary hearing this evening at 1:30.
Okay, so you're gonna see him today at 1:30.
Correct.
On something else.
Right.
Okay. I don't know. So why don't I do this? Since you're in custody, who's your evidence hearing before?
Judge Slay.
That's correct, Your Honor.
Before Judge Slay? Okay. Let me do this then on this case. Because I think an appearance came. Okay. So an appearance came in, I think, from him.
All right.
But I don't have it in front of me.
Okay.
So, and it's not really, it's kind of in our system, but not. So let me, I'm gonna just put it out 1 week. Okay. So I'll put it out to the 20th. It would normally go to the 27th, but let me put it out to the 20th, 2025 at 9 a.m. And then I'll continue your bond at this time. But if that date, let your attorney know if that date doesn't work, to get in contact with my office so we can get that sorted.
Okay.
Okay?
Right,
Thank you, sir. Court calls the case People versus Taisha Morgan.
Ashley Lonnie for the people.
Asli Bashir here with and on behalf of Taisha Morgan, who's appearing via Zoom.
Morgan, can you state your name, please?
Taisha Morgan.
Thank you. What are we doing?
All right, we're seeking for a brief adjournment, 2 weeks for further negotiations.
Probable cause conference, March 6, 2025, 9 a.m.
Thank you, Your Honor.
Bond, thank you. Court calls the case People versus Sunita Payne.
Ashley Lonnie for the people.
Who's with Jay?
Hello. Sorry.
Scoot over just a little bit. Yep.
Your
Nice.
name?
My name is Sunita Payne. How are you?
I'm doing well, thank you.
And Assistant Public Defender Jay Bellinger, Your Honor.
How come Miss Mackey's not doing it?
Oh, you're more than welcome to.
No, you too. I was just covering, just in case he was in here. I got his back.
Yeah, but
Oh. I have some support in this courtroom, Your Honor. It's nice to know that.
Outside the courtroom too.
Oh,
probably not as much as you think. But no, I'm just messing. All right, go ahead, Mr. Bellinger.
Your Honor, I did just send I did just send a mitigation letter over to the prosecution for review. I'm asking for consideration on that. So I'm asking for 3 weeks as an adjournment, and I'd like to briefly address a bond condition.
He's out.
Yeah, a condition, not
not release. Okay, gotcha. Miss Payne is just staring at you like, oh my God. March 6, 2025, 9 a.m. Yes, Esteban.
Esteban, Your Honor, my understanding is that there is a current no contact order between Ms. Payne and her son. I am asking that be lifted. I understand the allegations in this case. Tomorrow is Valentine's Day. My client informs me that that is a very special and important date between her and her son.
Sorry, is what?
Valentine's Day.
It's tomorrow?
2/14.
Oh, wow, man, they gotta do some stuff. No, go ahead.
I get it. Right there with you.
Oh, wow.
We are asking.
Let me know, man.
We are asking for the no contact to be lifted in this case. I want to verbalize that on the record for Ms. Payne's sake.
I'm sure there's going to be a response.
Your Honor, we are opposed to any change in the no contact order at this time. The court can tell from the charges in this case.
Look this way. Go ahead.
What's kind of going on here, I will tell the court that the child, the other parent, has full custody. And there was a visitation that was set up that led to some of the circumstances in this case. I can go into more detail. I feel more comfortable doing that at the bench of the court. I'd like to have more information about the facts and circumstances surrounding this case, but it's a very scary and serious case, and I do not believe that there is going to be any desire from the other parent of the child to have any contact between the two, given that the last time that there was physical contact or visitation, this is what happened. People are extremely concerned about any contact at this time.
Okay, so just so that I don't necessarily know any of the details, but is there a circuit court or family court matter pending?
Yes, Your Honor. There's an order, I believe.
Okay, and I understand what you're asking, Mr. Bellinger, but has that court permitted in any way the contact that you're requesting at this court?
Your Honor, it was unclear to me based on my read of the police report, and I didn't see anything specific in Odyssey that stated that the no contact was or was not at the discretion of the other custodial parent. There was no record that I saw that stood out to me that reflected whether that had been lifted or whether or not there was contact that was permitted. I suppose, Your Honor, I would suggest to myself and the prosecutor that if I can do a stip and order at a later time, if the custodial parent is okay with supervised visitation with the minor child.
But hold on a moment. The problem that I'm having here is typically, it's my experience has been in these cases, there's an order that's entered. It basically delineates custody parenting time. That when something like this comes up, that may alter that order.
Yes.
What would have been the original order? There may have been an original order that was, say, a standard order. That when something like this comes up, that order then gets altered to something else. I'm not going to order anything that may
negate or
may interfere or even just cause some confusion with that order that has been entered, either the initial one or the one that may now be in place.
Okay.
So for those reasons, what I'm going to do is I'm going to deny your request for any modification regarding the bond conditions. I think the appropriate place that you're going to have to go is going to have to be the family court. I don't and won't have an issue if they change their order, changing this order.
Okay.
But I'm not gonna do it that way, given the nature of the charges here.
I understand.
I'm not gonna do it in the reverse. Okay.
All right. Thank you.
Court calls case People versus Aaron Piccini.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Machini, who's on Zoom. Mr. Machini, please state your name.
Uh-oh.
Aaron Pacini.
Oh, okay. It's a bit delayed. Okay, we got you.
Your Honor, we are requesting an adjournment. Mr. Pacini is in the 14B recovery court. We have presented a possible resolution to the people. They just need time to.
To try to get through that.
Correct.
Oh. March 6, 2025, 9 a.m. Bond continue. Thank you, Mr. Pacini.
Thank you. Thank you.
Court calls case, People versus Thurman Pool.
Andrew Childers appearing on behalf of the people.
Ashley Moten, Assistant Public Defender, appearing on behalf of Mr. Poole. State your name.
Thurman Pool. Thank you, sir.
We are requesting an adjournment.
Of
We have.
course you are.
we have
Go
not-
ahead, what?
Well, we haven't received the media to go over with it with Mr. Poole.
Yeah.
Hey, it's not my fault.
Probable cause conference, March 6, 2025, 9 a.m. Bond continued.
Thank you.
All right. Thank you, sir. Court calls case, People versus Alan Reed.
Andrew Childers appearing
morning,
on behalf of the people.
Sorry. Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Reed. Your name, please?
Alan Reed. The loudest ever coming out of those pews. I don't know, what was he doing? No, I'm just messing with you. Go ahead.
Your Honor, we're requesting adjournment. We did review some of the videos today, and I did provide a copy of his discovery to Mr. Reed. So he just wants some time to review everything before deciding what he wants to do.
Gotcha. Okay. Probable cause conference, March 6, 2025, 9 a.m.
Okay.
Thank you.
Bond continued. Thank you, sir. Court calls the case, People versus Ronnie Richards.
Ashley Lonnie for the people.
Stephanie Cannon on behalf of Ms. Richards, who is appearing by Zoom. Ms. Richards, could you please state your name for the record?
Lonnie Richards.
Thank you.
You're welcome.
I have a plea form in front of me. Is that what we're doing?
That is correct, Your Honor. It's a no contest plea. The court should have the police report.
I do, and I've reviewed it. She's gonna need to be in a quieter place, though.
I think it's the type of device she's using. Ms. Richards, is there a way for you to go somewhere where it's less ambient noise?
There's no noise.
That's the correct term.
Jesus. Andy. He don't use those big words in Genesee. Anyway, go ahead.
Do you put the?
Yeah.
Okay.
I think they're kind of.
Oh.
Yeah, okay.
Is that?
Yeah, that's good. Can you hear me?
Yes.
Okay. All right. Why don't we try that? That's better than what it was. I have before me a plea form that indicates that she's going to plead no contest to the charge of use of methamphetamine. That's a misdemeanor, the 1-year misdemeanor. Upon her successful no contest plea to that charge, count 1 would be dismissed. That's the court's full understanding of the.
Yes, Your Honor, that is complete. Agreed.
I'll give it a shot, but I don't know how far we can get with this. Ma'am, can you please raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. State your name for the record again for me.
Ronnie Richards.
All right. You can put your hand down. Ma'am, it is this court's understanding that you're going to be pleading no contest to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right, two things I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, I understand, Your Honor.
All right. Basis for the no contest plea, counsel?
Potential civil liability, Your Honor.
All right. So, ma'am, to that charge, how do you plead?
No contest?
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I do. I understand. Thank you.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that? Well, you're going to have to say that again. You broke up there.
I understand.
All right. Okay. You understand you're giving up your right to appeal of right, ma'am?
Yes, sir. I understand.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, I am, Your Honor.
All right. Court has been provided and has reviewed Michigan Department of State Police report for their case number 5582-23. Any objection to the court having reviewed that report?
No, Your Honor.
None, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Court satisfied.
You have, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed.
Your Honor,
A pre-sentence investigation and report is ordered at 14A2 probation.
we would just stipulate to the lab as well, Your Honor.
Understood.
Thank you.
Sentencing in this matter,
10 a.m. before Judge Barr.
March 11th, 2025, 10 a.m., Judge Barr.
Okay.
Thank you so
March
much, Your Honor.
Thank you. Bond
Thank
will
you.
continue. Thank you.
Okay, thank you.
Court calls the case to reverse the charge young.
That is on behalf of the people, Your Honor.
Defender appearing on behalf of Mr. Young. Approaching, state your name.
Rashard Young.
Your Honor.
Yeah. Okay, if it's you, Miss Linda, okay. Mr. Allen. So you may want to, you may want to push that mic.
Oh, I'm sorry. This one?
Go ahead. While you're talking to him, you hold the mic, but I didn't.
Okay. Did you have other one? Is this your last one?
I only have one other case, but I'm not passing it.
Okay. You said just hold this down.
Yes.
Okay.
All right. Back on the record in this case. All right. Ready?
At this time, the people who said it's 25,000 without the 10%. In this case, the defendant has a companion case in misdemeanor court 1482 from 2024. It's a DV assault with the same victim, and I believe her son. He also has a case out of Plymouth for a domestic violence with the same victim. And in this case, it is an FA with a knife in which he threatened the victim with the knife, took it out while they were arguing, pulled it out, brought it up, brought it down towards her. And while he was in custody from, I believe, 2-3 to 2-6, he made 135 calls to the victim, which was against the conditions of his bond, which was addressed at arraignment. We have great concerns for her safety as he keeps contacting her and getting new cases for domestic violence with the same victim. And we'd be asking that at this time, his bond is set at 25,000 without the 10%. Into custody, Your Honor.
Response.
Okay, regarding the actual charge, I did review the discovery myself. The evidence is solely the testimony of the complaining witness. There has not been any evidence of a knife. Regarding the phone calls, my client does deny all of those allegations. We have not received a violation report to discuss that with him. I was going to ask for an adjournment because we have not been able to speak about this case. I was going to ask for a week adjournment so we can go through the evidence and possibly at that point we can, address bond again at that hearing.
But he's indicating that calls were not made from the jail?
He's saying it was not him making the call. He did not make any calls to the complaining witness.
And I believe they were from his PIN to her number stated in the police report. And given that he already has multiple other cases with this victim, I have great concerns that he would still be contacting her out of custody.
I would ask, he is, okay, he is, your phone was. Hold on, let me give you the it is my understanding that he is gainfully employed. He is a father. I would ask if he is, he can remain out on bond with a tether.
Well, but I'm a bit concerned about all of this contact. I mean, I've got these cases coming up while we were at the bench so that it's clear. Prosecutors indicating to me calls are coming from the jail from up to the 6th when he's released on that day.
Mm-hmm.
But he's arraigned on the 4th, and it's clearly indicated he's to have no contact. So, and if it came from his pen, I mean, so I'll adjourn this to February 20th, 2025, 9 a.m. I'll adjourn it out 1 week.
Would we be provided with the calls?
Yes, I'll send those out to, or I'll send an email to have those released today.
I'm gonna set his bond at $25,000 cash surety as the amount. What was his bond set at initially? Personal?
I believe it was the 25,000 yard with the 10%. And then the other case, he got a nominal $100 bond on the mistaken case.
All right. So defendant's gonna be remanded. He'll need to post that. And then at this point, defendant's phone privileges, given what the court has heard, are revoked. So that he'll go into the jail. He won't have phone privileges. Is the court's intention. And then you can get those through with your client, and we can figure it out next week. But at this point, defendant's remanded. Court does call the case People versus Brandon Carter.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Carter, who I believe is on Zoom.
No, if he is.
Your Honor, we had communication with him. It was my understanding he was in Wayne County Jail. He was transferred from Washington County to Wayne County. He was released last night from Wayne County on a tether. We had contact with him just this morning and provided him the Zoom information.
Maybe this is him. I got one person on. Mr. Carter, you'll have to unmute. Do we know who 2025?
Let's see what his number.
Sorry. Oh, hold on. That may be him. Mr. Carter, you'll need to unmute. Is that him?
That appears to be him, but
I'm here.
Just based on his booking.
Okay,
Yes,
what's your name?
I'm here. Brandon Carter. I'm sorry about that. I was giving my son some diapers in the CVS. I'm
Okay.
sorry about that. I'm sorry.
You're requesting an
2
adjournment.
weeks.
Yes, Your Honor. Now that he's out of custody, we can meet with him and
I do have I have a bond violation report on him.
I think that was because hold on, Mr. Carter. My
Yes, sir.
understanding in the report is because his tether died when he was in Wayne County. He was in Wayne County up until last night.
That's considered.
I will say, Judge, he informed my intern that they took the cord into his property in Wayne County when his charging cord, and they lost it. And so he doesn't have it. So I'm going to need Mr. Carter.
These tether cord get lost.
It was booked in his property when they released him. They said that they didn't have it.
Okay.
So
that's fine. All right.
If I can get a chance to give him an opportunity to get to community corrections and get a new charger before there's any new.
March 6, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. And Miss Apple?
Yes, sir.
Approach, please. 14A stands in recess. Yes.
Sorry.
Turn on behalf of the people.
Good afternoon, Robert J. Cole on behalf of my client, Ms. Ozawa. Come on over here. Judge, today's the time day for PCC in this matter. Oh, I'm sorry, state your name.
Yes, my name is Mizuki Ozawa.
Thank you.
Judge, today's the time of day for PCC in this matter. I've had some discussions with Ms. Curry. She would like a couple of weeks to try and resolve this matter in an equitable fashion. So we're asking for a 2-week adjournment of the PCC.
Okay.
I explained to my client, I asked her if she needed a translator, but she and I spoke about this and I explained to her the adjournment. I think we're fine.
You're fine for today,
Yes.
but
Yes. I think we're going to try and resolve this short of.
okay. Okay, that's fine. You want the 27th or the 6th?
I'm sorry?
The 27th. I'm on here.
27th.
27th is fine.
Public cause conference adjourned February 27th, 2025, 9 a.m. Or as your invite indicates, bond continues.
Thank you, Judge.
Thank you.
Thank you so much.
No.
Okay.
No.
Okay.
No. 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 Oh, no. Court calls the case. People of the state of Michigan versus Terrence Robinson.
Stephanie Cannon on behalf of, sorry, Your Honor, he is not here. Thank you.
Thank you. He was just right there. On behalf of
He was just right.
Terrence Robinson, he was, Your Honor, he was like this tall.
So when you said he's not here, you mean he's in the building, he's just not.
Yes, he is here. We just met. He came in right behind me. I don't. Your Honor, yes, he's the very tall one.
Light gray sweatpants.
Yes.
Wow.
She saw him too.
Apparently.
That does not seem to.
It also describes the Jolly Green.
He did also check us out.
So
Your Honor, can we just pass this for a few more minutes?
if I said no, what would you do?
I-
You don't know. I'll pass it.
Thank you, Your Honor.
Seems to me if you look in the hallway, given that description, you can't miss it. Court calls the case. People versus Michael Rudisil.
Stephanie Cannon on behalf.
You don't have that one either? Cannon, you don't have that client either. You know what? All right, I'll pass that. We'll just pass it to the Cannon docket. Court calls the case of the people versus Gabriel Stevens. Please no. All right.
Ashley Long on behalf of the people.
Ashley Moan, Assistant Public Defender, appearing on behalf of Mr. Stevens. State your name.
I'm Gabriel Alexander Stevens.
Thank you.
If we,
Thank you for being here.
if we may get a brief adjournment, we're in plea negotiations.
Your Honor, I understand this person's co-defendant was adjourned to 2/27. Would the court
Was-
please speak to that?
All right, very good. Thank you. Probable cause conference will be adjourned February 27th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case People versus Fabian Thomas.
Andrew Childers. Andrew Childers appearing on behalf of the people.
And public defender fellow Nicholas Bukovich on behalf of Mr. Thomas, who should be appearing via Zoom. I did have a conversation this afternoon with Mr. Thomas confirming he had the Zoom info, so.
Can you guys hear me?
Hold on one moment. The Japanese interpreter K, I don't think we're in any need.
Yes, sir.
Hello, Madam Interpreter. I just saw you on Zoom. I didn't pick you up. We are no longer in need of interpretation services
Great, thank you so much.
for today.
All right.
Thank you.
So much. Good night. Bye-bye.
All right, go ahead.
Yes, Your Honor. I'll be requesting a brief adjournment to finish the mitigation process, approximately 3 to 4 weeks.
All right, he's here.
He is here.
Sir, state your name.
Fabian Thomas.
All right.
I understood he's been interviewed, but he needs to finish the writing of the report and the supervisor needs to check it. So that's why I'm asking for 3 to 4 weeks to give adequate time.
March 6, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus Adrian Vasquez.
Ashley Long for the people.
Hi, Your Honor. My name is Adrian Vasquez.
That's right. Read this.
Did you say your name already?
Yeah, he stated his name. He was here long
was
before
here.
you were.
Thank you.
All right.
We are just requesting a 2-week adjournment. Restitution is going to be a question in this case. I do believe we are going to resolve it very shy of trial, but we just need to know the restitution, if there's a
The
restitution.
amount?
Yes.
That's what, okay. I'll adjourn it to March 6, 2025, 9 a.m.
You need this?
No, that's fine.
Okay.
Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Aaron Washington.
Sophia Curry appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Washington. Will you state your name for the record?
Aaron Washington. Good afternoon.
Good afternoon.
Your Honor, I'm asking for an adjournment on this file. I don't recall if the court remembers or recalls, but there was a situation involving a potential new case stemming from a bond violation. Found out that that was going to be coming through the Ipsy Township prosecutor. I did reach out. I haven't received a response on that status, but I'd ask for another adjournment to try.
So you're looking to try to resolve that case along
Together.
with this? All right.
Yes.
What I'll do then is probable cause conference in this matter. I'll adjourn out to March 13th,
Thank you, Judge.
2025, 9 a.m. All right.
Okay. Thank you.
Thank you, sir.
All right.
Court calls case People versus Ryan Wheeler.
Echelon of people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Wheeler, who approaches. Right. I can't look at you without laughing now.
Oh, thank you.
Not like that.
No, that was a good thing to do, Judge. All right.
Can you say your name for the record?
Ryan Wheeler. Thank you.
Your Honor, I have been in conversations with Ms. Londe. We are seeking any additional discovery before setting this for prelim. We were asking for 2 weeks in order to see if that exists.
That's correct, Your Honor. I reached out to the sheriff's department, and while there's only one video that's categorized with this case, there certainly should be more. So they're checking with deputies to see if they maybe got mislabeled somehow, and so we can get them matched up with the right case.
Got it. Okay.
Make sense? Okay.
So what I'll do.
Okay.
Grant,
No, none of that.
I'll grant the adjournment. I'll adjourn the matter, probable cause to March 6th.
March 6th.
Thank you, Your Honor.
All straight.
That's as soon as you can give us. We need to.
2025, 9 a.m. Or is your invite in? Bond continue. Thank you.
I'll talk to you. Thank you, Your Honor.
All right.
Court calls case People versus Monet Wilson.
Sophia Curry appearing on behalf of the people.
Ashley Moten, Assistant Public Defender, appearing on behalf of Ms. Wilson, who is approaching me. Monet Wilson.
Thank you.
We are requesting a preliminary exam in this matter. I believe we have all of the discovery.
Hold on a second. They need to. Good job, Al. Go ahead.
We are requesting a preliminary exam. I do believe all of discovery is complete.
People have their witnesses available the 25th.
Do our best, Your Honor.
All right. Preliminary examination in person, February 25th, 2025, 9 a.m. before Judge Barr. Bond will continue. Thank you. Court calls case People versus Jelani Wright.
Echelon for the people.
Thank you again.
You're welcome.
Assistant Public Defender Asli Bashir here on behalf of Mr. Wright, who approaches. Mr. Wright, your name?
Jelani Wright. You take your hands out of your pockets.
And Your Honor, I've spoken with Assistant Prosecuting Attorney Londi, and there appears to be some potential outstanding discovery. So we're waiting on kind of follow up on that. So we've requested a brief adjournment.
All right. Probable cause conference will be adjourned March 6, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Ernest Cesar.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Asa Bashir here with
Ernest Zazar.
you. And-
Sorry.
It's okay.
Silly me.
And I request a brief adjournment for mitigation and for further negotiation.
We'll adjourn this matter to February 27th, 2025, 9 a.m. or as your invite indicates. Bond continue.
Thank you, Your Honor.
Thank you, sir.
Thank you, Judge.
This is that case, right? I'll recall the matter of the People versus Rashad Young.
Alex, and on behalf of the people.
Oh, there you are. Okay, I didn't know where you were at. It's like,
Ashley Moulton on behalf of Mr. Young.
yes, and Mr. Young, he was taken into custody, transported down. He is not here. I'm not bringing him back up only because my understanding is the alleged victim wanted to address the court. So if we could get her. Your name?
Tandiana Yates.
All right. Ma'am, I'm gonna let you know, if it weren't for the people in the prosecutor's office and counsel, I wouldn't be calling your case back up and you probably would have been locked up. I'm just gonna let you know because you don't come into the court that way, ever. Am I clear?
Yes.
What did you want to tell the court, ma'am?
Okay, first I want to say I fully apologize for coming in here like that. I was unaware. I'm sorry. I just want you to know with this whole case, instead of incarcerating somebody,
Go ahead.
y'all need to try to help him. I don't know if the prosecutor let you guys know, but he has yes, I'm sorry. You can talk. I don't want to overtalk you.
Well, you'll never do that, but I'm just gonna let you know that I'm not going to sit here. You wanted to address something to the
Yes,
court,
because I
and
feel like it was
I
inaccurate.
I will listen to you. I'm not gonna tell you or have you sit here and try to give me a lecture on how something should work.
Oh, no, I would never do that, but I just noticed when I was looking on the Zoom that it was inaccurate information stated on you guys' record, and I just fully disagree when inaccurate information is stated on something that's very important like this. With the prosecutors, they should have called me instead of giving out inaccurate information because I would have just let you guys know. Instead, when I looked on that Zoom, it was inaccurate information stated on this, I don't know what you call, in this courtroom, and I just fully disagree with that, so I wanted to make that known.
Okay, let me just say this because you kind of blurted that out when you had come busting in here.
And my apologies for.
So let me just tell you so that you can understand what you're saying and what is being said. Because when you said that, which is everybody's obligation here, his counsel, the prosecutor, and even in some respects the court, to double check what somebody is saying, in particular if a decision was made based upon inaccurate information. Let me tell you that the prosecutor, as with her duty, checked what you were saying. I don't think, at least preliminarily, and I discussed it with his counsel and with the prosecutor, that what you're saying is correct, that it was inaccurate. At least with reference to what I was using for my decision on the remand. There will be a hearing that will be set next week. At that hearing, all of that will come out. But at least preliminarily, it does not look like the information that was presented to the court was in any way inaccurate. Some of the information with reference to the date, so that you understand, the court itself can tell in looking at the file and when he was arraigned. So while you may have your position that it's inaccurate, I do not believe at this time that it is inaccurate.
Okay, so is there any way that a prosecutor, an actual someone can call my phone so we can discuss this? Because I no longer have that cell phone number and it was to my sibling. You guys stated on,
If there are references to the case, ma'am, we thought about that.
okay,
If there are references to the case, references to you, references to other things that are occurring. So I don't think, and I said, I have not made a final decision on it certainly, but at least preliminarily, what is being represented to the court appears to be true. And we will flush it out at a hearing because that's the way our system works. Preliminarily, I have that. I took what remedies need to be done to enforce the orders of the court regarding no contact. It seems that that was violated. He will have his due process right to a hearing next week regarding that.
but how is it violated when I have not physically talked to him? Just like when I came into the courtroom the first time and I sat down, he made it aware that I can't even be around him.
I am not going to have a hearing on it right now. I will listen to you.
That's just very, that was just very inaccurate to me. And I just felt like the way that y'all did that was no. Somebody should have.
Y'all did what? Don't you turn your back on me, because I'm telling you what, you are trying my patience.
No.
You are trying my patience. I brought you back in here after you acted like that to listen to you. And then you're not going to listen to a thing I said. I'm done. If you want to attend the hearing next week, you can come to the hearing. I've tried to explain it. You are not listening. I am done. Do not say another word to me. Mr. Allen, remove her.
Nobody.
Remove her. You keep talking and there's going to be a problem. There's going to be a problem. Ms. Cannon, do you want your cases called now? No, I'm good. I am so good, Miss Cannon. Are your people here? Oh, well.
Yes, Your Honor, they are here. They are ready and they are eager to just listen and learn from this honorable.
Court calls the case or recalls the case. People versus Michael Rudisil.
Thank you.
Why perfect?
Stephanie Cannon on behalf of Ms. Rudison, who is appearing to my right. Please state your name for the record.
Miss Cannon, it's okay. Do you need a break?
No, I'm ready.
You good?
I'm good, Your Honor. Thank you so much for giving us this opportunity.
Sir, can you state your name, please?
My name is Mike Rudisil.
Thank you. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of improper transport of a firearm in a motor vehicle, the 90-day offense. Upon his successful plea to that charge, count one would be dismissed. That is the court's full understanding of the agreement.
That is correct, Your Honor. That is correct, Your Honor.
Has he signed in? He has. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Mike Rudisil.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of improper transport of a firearm in a motor vehicle. That's a misdemeanor punishable by up to 90 days incarceration, $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Freshour, 1484 District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of rights.
Yes, sir.
Are you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no,
Anybody threaten you or coerce?
no.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you're guilty of this case, of
Yes,
this
sir.
offense? September 1st, 2023, at the location of West Main Street near Washington Street in the city of Manchester, Washtenaw County, state of Michigan. Were you in a motor vehicle?
Yes.
Did you have a weapon or firearm in that vehicle?
Yes, sir.
Where was it located?
And center console in a case.
All right. And you did not have the authority to transport that weapon in that fashion, is that correct?
No, sir. An expired CPL.
Pardon?
An expired CPL.
Got it. So you did not have authority to
Correct.
transport in that fashion. Counsel, have its court complied with the court rule, would it be proper to accept this defendant's?
The people are satisfied. You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be April 15, 2025, 9 a.m. before Judge Freshour. Bond in this case will continue. Thank you, sir.
Off of probation so they can talk to you. It's called pre-sentence investigation report.
Think about this one.
Oh, you know what?
Court does call the case of the people versus Terrence Robinson.
Stephanie Cannon on behalf of Mr. Robinson, who's appearing to my right. Mr. Robinson, could you please state your name for the record?
Terrence Robinson. My mother is here too.
Your Honor, my client has decided that he would like to exercise his right to a preliminary exam.
All right, they don't have a problem setting a preliminary examination. Well,
So this appearance clerk's office by your office mail today. I don't have any on it.
see.
Yeah, let me see if I can email someone.
Counsel approach.
Yes, Your Honor. Don't talk unless the judge talks.
But I need to be quiet now. Okay. Thank you. Remember, let's come over. And there isn't anything to be right. Because remember, we were looking up. Oh, no, there it is. But they didn't get it. Yes. But I remember.
You're not talking about a previous case.
Well, I don't know.
Or a different case.
It might be.
And that might be a problem because I actually had docket where the jail was a weird order. So I went to an on-base issue.
I see.
So they took my.
I told the judge they took your minutes. They're gonna go over. Correct.
5 days.
All right. So I gave you a copy of the bond violation report, and the bond violation report indicates that the defendant was placed on the tether per court order. And hasn't been keeping it charged. There's also an indication that he was released from the jail, and the jail nor community correction staff knew that he was to be placed on a GPS tether. However, no court documents spoke and they were released. So the issue, my staff thinks, but we don't know, may have really been our communication system that from arraignment would have sent those documents to the various agencies.
Understand.
Okay, so that may have been it, and why when the request for the warrant came over, I did not sign it because I wasn't sure. I mean, I could see it in the file, but I did not have a narrative of what allegedly transpired. Okay, so I'm not gonna find a violation or anything, and I don't have a problem. He wants it set for preliminary examination.
He does, Your Honor.
All right. So, Mr. Robinson, here's going to be the problem, and I can overhear you when you were talking up there. Whether or not I put you on it or not is, in certain respects, irrelevant. A judicial officer has ordered you on the GPS tether. So, what I'm going to suggest to you is that you comply with that order. Okay.
I will, because you told.
Okay. So you got to make sure to put that on, have it charged. Okay. You got it? So I don't want it. So I'm just going to be blunt with you. I don't want to get a report saying he doesn't have a charge, because now I know I told you. Okay. And you can be mad with me if you want, but you know how I am. If people get mad with me, I don't care. Okay.
I don't get mad.
Okay. So then the next thing is, so I want you to do that. Now, the next thing is, and what I'm worried about, you haven't been taking anything, have you?
I've been going into recovery, and during this process, I have fell off the bandwagon. So
You did what?
I have fell off the bandwagon. I've been trying to get into recovery. I was at the hospital going into home of New Vision. They wouldn't let me in there because I didn't have my meds. The jail took my meds. They won't let me in there because I don't have my proper prescriptions to come in there. And when I tell you it's been a runaround.
Okay. All right. Hold on a second. So here's what I hear you saying to me. Okay. And you tell me if I'm wrong. You're supposed to be on certain medications. You're not on those medications right now because for whatever the reason is, you don't have access to them. Right? Okay, so now do you get those medications through your doctor or are you with CMH?
CMH.
You're with CMH?
What is CMH?
Community Mental Health.
Yes.
Yes, that's okay. So that's where you get those, right?
Yes, and to save a long story, it's just there's a problem with my insurance and all this type of stuff. But I'm still working on that. But the jail would have just gave me one.
Okay, hold on. Just
all right.
Red, let's do this. Let's step away from trying to blame anybody. Let's get you back on your meds if you can. How about that? Fair enough? Okay. So it's you. It's you.
It's 100%.
No, it is
It's
100%
100%
you.
me.
It is you. Everything was going fine my whole day.
It was.
And then you. Yeah. All right.
Your Honor, is there a way for me to go to the jail to get his meds? Will they release his?
I don't.
To me.
I don't know what the jail has done with those.
So the problem is apparently they had just been refilled in their psychotropics.
So he can't. Right. Okay. So I don't know.
Okay.
And what I'd suggest that you do is you call jail. See what? No. I know you called the jail. I'm gonna have other people call.
I got something else for you.
Okay.
Permission to speak?
Yeah, go ahead.
I talked to my brother Andrew Robinson, as sheriff. He talked to the captain. The captain told me exactly what I was supposed to do. The captain of Washtenaw County. I'll go fishing, whatever, don't matter. But they said to tell them I have identifiable meds. So I have to call him again. But he said, if I don't say it like that.
Okay. All right.
Understand what I'm
Just
saying?
listen.
But-
Why don't we do this? I'm gonna let your attorney work on that,
We'll
okay?
we'll do it together today, okay?
Okay? Because maybe she doesn't have to say the same things that you say,
Okay.
okay? So we're gonna do that. And then because of the, we need a new order.
I did verify that, yes.
Yeah, okay. So that hasn't been charged.
That I don't know.
No,
Maybe
he
like
hasn't
monetarily
charged
wise.
it. He hasn't. charged
Okay. Oh, probably.
it.
He hasn't.
Man. Okay, so I'm gonna let your attorney check into that, see if they can get it back. You have a worker with CMH?
Yes,
Have you, okay, have you talked to them?
yes. But
Okay,
I'm telling you. This tether right here is giving me a hard time.
no, the tether's not giving you a hard time.
Okay, well, then maybe it's not the tether.
No, it's not.
Me not having my meds.
That's
I
what's, that, I got you.
cannot.
That's what's giving you a hard time.
So
So,
it's causing me to come back out into a world that I've been long far away from.
I hear you. So that's why what I want to do first and foremost is I want to get you back, see if we can get you back on your meds. Okay? So I don't want you worrying about the tether. Don't let that bother you. If you get angry with the tether, then get angry with me. Okay? Because I'm putting it on you and we're going to sign a new order so that that happens. Here's what I want you to do. I want you, so Ms. Cannon, you're going to try to check into that and.
It's my last case, Your Honor. I'm going to go address it now.
Okay, so we're gonna try to see what we can do for you on that end, okay? Make sure to give Miss Cannon who your CMH worker is, so that she can reach, that's Miss Cannon, okay? So that she can reach out if she needs to that person, as well as talk to the sheriff's department and see about this other thing, okay? All right, but one thing I want you to do is I also want you to get yourself over to community corrections and make sure your tether unit's working. Okay. Now, Mr. Robinson, your counsel's asked me to set this for a preliminary examination. Is that what you want right away, or you want me to adjourn it out a couple weeks and see where we are and sort of monitor where your meds are and stuff like that, and then make a decision what to do with your case?
A speedy trial, because this was very.
Okay, I don't want you talking about the case itself.
Speedy trial.
Okay, so you want, all right. So let's do this then. And Miss Cannon, your discovery is complete.
Your Honor, this is actually Attorney Feaster's case, and I'm so happy he shared it with me. And he told me
A little bit more sincerity in your voice.
he told me to set it for a preliminary exam, so I'm going to have to
Oh,
say
that's
to
what
the best
he
of my
instructed. Okay,
knowledge that
That's
the
fine.
case is ready to move forward.
all right. And would the people be able to have their witnesses available the 25th?
Yes, Your Honor, we'll do our best. And
All
I'd
right.
just like to address one matter before we're all done.
Okay, that's fine. So what I'm gonna do is I'm gonna give you your preliminary examination, okay? I'll set it in person, February 25th, 2025, 9 a.m. And I'm gonna set that before me,
Okay, thank you, Your Honor.
okay? And then, yes.
Your Honor, thank you. As I indicated at the bench, I have some concerns in the moment about whether or not there's impairment in play also. I understand we've discussed mental health issues that may be in play. I just would like to hear that assault and strangulation occurred when my certainly endeavoring to address all these issues. I'm worried we're going to have somebody walking out of the courtroom that doesn't have a tether on them. Probably has mental health issues in play and may or may not also be impaired. At least order test maybe.
I am going to order So let me ask you this.
I wanted to treat me, Your Honor.
No, just listen to me, okay? Because I'm going to need you to do some things. All right? I'm going to ask you a question. I just need you to be honest with me.
Yes.
All All right. If I send you over now for a drug test,
I'm gonna drop dirty, sir.
you're gonna drop dirty.
Yes.
Okay. Let me ask you
That's
this.
it.
Hold on, just hold on.
Ms. Robinson.
What's gonna show up in your system?
Cocaine. It would be cocaine. It would probably be alcohol from last night. And it would probably also be, I did get it, but I'm prescribed that.
Okay, so let's do this.
And Suboxone probably be there too.
What you say?
I'm prescribed Suboxone. So I'm staying away from.
Hold on a second. So you're prescribed Suboxone.
Yes. So what I am doing is what do you call it? I'm self-medicating because
Yeah, I know.
I can't get my meds.
Okay.
That's not, I don't do this. That's not what I do.
Okay. All right. So didn't necessarily expect all of that.
I'm gonna keep it real.
So, Mr. Robinson, here's what I'm gonna do. We got to change the plan. Okay, I'm just gonna let you know. Because now I'm really worried about you. Okay.
I need my
No, you need to listen to me.
Don't take me to jail.
Huh?
You really about to put me in jail? I'm going to
Tell me, hold on.
I'm going to go through everything.
Mr. Robbins.
Home and New Vision is waiting for me right now. Once I get my meds, and you can, this is all verified.
So just listen. Here's the way I'll do it. I am gonna
do not arrest me.
Just listen. Listen to me. Because I don't want to make this any more difficult than it has to be. Mr. Robbins.
I'm listening.
Now, here's what I want you to do. I'm going to have my bailiffs take you in. I'm going to ask counsel to call. Just listen. I'm going to have your counsel contact Home and New Vision. If they tell me what you said and we can get your meds, then I'm going to let you right out and let you get there.
Yeah, long as
okay. I don't know.
I swear before the court, Your Honor.
Mr. Robbins.
A bid for me.
Mr. Robinson.
I don't want to go in that motherfucker. Shit.
Okay.
Sorry.
I ain't going to take those words.
I apologize.
My bailiff's going to take you. We're going to check on some things and then figure out. Go with my Mr. Robbins. Just go with my bailiff. Because if you make it difficult, we're going to have a real problem.
Actually, remember, you can drop me. I'm probably clean. That was a good.
Yeah, okay. We'll figure it out.
Yeah. The shirt from?
All righty. No, thank you. All right.
By the way, this is,
Well, yeah, that's kind of his. Okay, so my next block is 20 minutes ago. But I'm going to step off. Then I'm going to maybe come back. Are you going to be here? Are you Cannon, are you done for the day? No, right. I just want you to go check up on all of that. But if I walk back in here and you've got a case.
I'm done.
Yeah, okay, good. You have done enough damage today. Court does call the cases of the people of the state of Michigan versus Alice Elliott and Samantha Lewis.
Sounds.
And the Attorney General would state your appearance.
Good afternoon, Your Honor. Benita Hoffman, P483. I'm sorry, P48738.
This is a prosecutor.
Oh. On behalf of.
Sorry. Yeah.
Thanks. All right, we have you breaking up. All right, counsel.
Go ahead. Patrick Ninehouse on behalf of Miss Elliott.
Good afternoon, Your Honor. Good afternoon to your staff. I'm Mayor Macklin representing Ms. Samantha Lewis, who's president standing to my right. Samantha, state your name.
Samantha Lewis.
Alice Elliott.
Thank you. All right. Where do we need to go on this case, folks?
Your Honor, we are in receipt of some discovery. I did receive a thumb drive from the AG's office. I think Mr. Nahas did as well.
Yes, that's correct.
So I believe that we are in full receipt of the discovery. With that being said, we'd like to set an exam. And I'm mindful that the court set an exam yesterday for a continuation for the 10th.
This one's not before me.
This one's not going to you?
Oh, no.
Okay.
I mean, I didn't mean to say it that way, but
Yeah.
it will not be before me.
Okay. Well, whenever the next available date would be, Judge.
It would. It's another happy customer. This one would. Date I have available for this. Do you anticipate that it will be as lengthy as the other one?
I don't think so, Your Honor, because we don't have 7 defense attorneys in this case.
A blessing. Yeah.
So that may make it work way smoother.
Well, right, but if
but the number of witnesses may be the same. I don't know.
maybe about the same. Okay. All right. That's, I guess, what I was looking at. So I will. Would the people have their witnesses available March 11th?
I believe so. Let me take a quick look.
Yeah, Judge, can we get a
And Your
different date
Honor,
than the 11th?
I'm scheduled for a jury trial on the 11th. Could we do the 12th? Or the 18th?
The next week.
Well, I was setting it on a Tuesday. Okay.
Really?
How does April 1st work?
I won't be in town on the 1st, Judge. If we can go maybe.
Well, here's what I'm going to do. This case will be assigned to Judge Washington. Now, what I can do is I can set it for the 11th and then let the parties work that out with her. I was just setting it on a date that I know that she will be here because her court is under construction. So space is going to be limited in certain respects.
So you're saying March 11th, Your Honor?
Yeah, I was good. What I'm going to do is set it for March 11th. We will notify Judge Washington that I've set it, and then the parties can work with Judge Washington to get an appropriate date that will work for everybody.
Very well.
All right.
Thank you.
Thank you, Judge.
Okay.
So preliminary examination will be set in person before Judge Washington, March 11th, 2025, 9 a.m.
Thank you, Judge.
Thank you.
Thank you.
Bond will continue.
Have a great day, you and your staff.
Yep.
Yeah, long time no see. Continue. Yeah, email that to Heather and yeah. Let Did you need Jeff or anything?
No, not at all.
One thing about me is I know how to clear a room. Court calls the case of the people versus Christopher Day. Is it Dia or Dick? How do I pronounce that?
Good afternoon, Your Honor. Michael Doby for the people.
Good afternoon, Your Honor. Douglas Kuchar, P64722, Chris Stitcher.
Christopher D.
Thank you. It's D. Okay. Yeah. All right.
Your Honor, I believe we are setting a date for our preliminary exam in this case.
That is correct. We have
All
received,
discovery is complete.
all the discovery.
And would the people have their witnesses available the 25th?
The 25th is fine, Your Honor. I'll be here for an exam before Judge Barr that day.
All right. Will that work for you, counsel?
Will, Your Honor. Thank you.
All right. This one is actually before me, but set a preliminary examination February 25th, 2025 I'll set it at 9. And bond will continue. Maybe we can, you said you have an exam before Judge Barr that same day. He'll be in the adjoining the side courtroom.
I played that game plenty of times.
Okay. So a little bit, right? I just was saying that, is that one that you're having before Judge Barr likely to go?
I think so, yes.
Okay. So, and this one would be likely to go. What I can do, counsel, is I can set this for you to just kind of alleviate time of waiting. And since this one's before me, I can set it in the afternoon because I'm here at this courthouse all day. And would you prefer that? I can.
Either is fine with me, Your Honor. I think in conversation with Mr. Gucher, we're able to limit the witnesses here. I think it won't be a.
Okay. Why don't I do this then, since this one's before me and I can adjust the time. I'll set this at 11 a.m. That way you're not coming down waiting. Save you a couple hours at least. Okay. Bond will continue.
Thank you, Your Honor.
All right. Thank you, folks. And Mr. Doby, can you approach on a separate matter?
Yes, Your Honor.
Calls the case, people versus Matthew Erickson.
Good afternoon, Your Honor. Allison Cass is on behalf of Mr. Erickson, who's approaching to my right.
Matthew Erickson. Thank you. Oh, you're just everywhere now.
Oh, I know.
No, go ahead.
He left as soon as he got here.
You're requesting an adjournment.
We are, Your Honor, approximately 3 weeks if possible.
Without objection, on the matter of March 6, 2025, 9 a.m. Bond will continue. Your Honor. Thank you. Court calls the case, the people versus Christopher Kerrang.
Allison Cass is on behalf of Mr. Cron, who is appearing by Zoom.
Sir, can you please unmute and state your name?
Christopher Curran.
Thank you.
And we would ask to set this matter for a preliminary exam. We're asking about 2 weeks out to February 25th if available.
Mr. Guerin tell you you can pick your own date?
Asked him which day he preferred.
Whatever's available for you guys. I'm straight up disabled and very, very sick, so I'm available. Whatever.
All right. Yes, sir. What I will do is people would have their witnesses available the 25th.
I'll do my best, Your Honor.
All right. Preliminary examination in person, February 25th, 2025, 9 a.m. That will be before Judge Barr. Bond will continue. Thank you, sir.
Thank you.
Court calls the case of the people versus Lawrence Savoy.
Ashley Lonnie for the people.
Allison Castles on behalf of Mr. Savoy, who's approaching to my right.
Old docket to her.
Morning, Your Honor.
Your name?
Lawrence Savoy.
Thank you.
We would also ask to adjourn this case out approximately 3 weeks to the same date, if possible.
Without objection, probable cause conference, March 6, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus, is it Zinyi?
Ready, Your Honor.
Go ahead, sir.
Your Honor, I was just waiting for a prosecutor to put their appearance on the record. Joe Simon. on
She
behalf
did.
of-
She
Oh, I'm
did
so
like
sorry.
hours ago.
Didn't hear it. So sorry.
Okay.
Ms. Hugh, unmute yourself. Joe Simon on behalf of Ms. Hugh. Ms. Hugh, please state your name for the record. Unmute your microphone.
My name is Xin Hu.
Thank you. All right. What are we doing on this case?
Your Honor, the people and I have just begun discussions. I understand from Ms. Rizmirsky, she was requesting a few weeks adjournment. It would technically be a joint request. I have no objection to that at all.
Probable cause conference, March 6, 2025, 9 a.m. or as your invite indicates, bond will continue. All right. Thank you. Court does call the case of the people versus Zihan Zhao.
Your Honor, Joe Simon on behalf of Mr. Zhou. Mr. Zhou, state your name, please. Joe. Mr. Zhou, can you state your name?
Hi, excuse me, can you hear me?
Yes.
Yeah, my name is Zihan Zhou.
And what do we need to do in this case?
Your Honor, we're asking the matter be set for preliminary exam. And I know you don't like me to pick dates, but can it be either the 4th or the 18th of March, either one?
I'm sorry?
Could it be either March 4 or March 18 for exam?
We'll have their witnesses available the 4th.
We'll try our best, Your Honor.
Preliminary examination in person, March 4th, 2025, 9 a.m. That is going to be before me. Yes, before me.
Thank you, Your Honor.
Thank you. Bond continued. Court calls case, people versus Matthew Gringas.
Good afternoon, Your Honor. Jeffrey Aboud appearing on behalf of Matthew Gingras, who is appearing via Zoom with permission from the court. We appreciate that. His wife's actually currently in labor right now. So
she's in labor?
She is in labor, but
well, we better hurry. Well, congratulations to you, sir, you and your family.
Andrew Childers appearing on behalf of the people.
All right, what are we doing? And Mr. Gringas, can you state your name, please? Your
Matthew Gingras, Your Honor.
Is it your first one?
Yes, Your Honor.
Okay, I could tell you were really nervous, couldn't find the mute button. All right. Okay. All right.
it will be setting up for an exam, Judge.
All right. Discovery is complete.
Yes, the discovery from the prosecutor's office. I think we're waiting on some FOIA to come back, but
that discovery
will proceed.
All right. And would the people have their witnesses available? Well, she just went into labor. You have a problem if I push it out beyond the 25th?
I'm fine with whatever works for the court.
Because your client would be asleep.
That's fine, Judge.
He doesn't know it yet, but all right. What I'll do is I'll set it preliminary examination in this matter in person, March 4th. Will that work for you, Council?
That works for me.
All right. March 4th, 2025, 9 a.m. That's before me.
Thank you.
All right, bond will continue.
Thank you, Judge.
Thank you. So good luck to you and best to your family.
Thank you so much.
Thank you. Court calls the case, People versus Lewis Goodine.
Andrew Childers appearing on behalf of the people.
I'm sorry. Good afternoon, Your Honor. Raymond Burkett on behalf of Mr. Cohen. And sir, Mr. Cohen, would you please identify yourself to this honorable court?
Yes, Lewis Howard Goodine.
Thank you. All right, what are we doing in this case?
Your Honor, Mr. Childers and I have discussed this extensively, and we want to ask you, would you consider at the time we had agreed upon a date when both of us were available because of our trials to March the 11th. But something that just came up and I just realized that there are certain parts of discovery that we don't have. I'm assuming the prosecutor can get it to us before that date. If not, we were asking, would you consider letting us have it on March the 11th?
Well, what discovery is outstanding? I don't set these till discovery is set.
There's several videos that are not coming clear to us on these reports, and none of the scientific things that we have. And my staff has told me that there are a minimum of 5 police reports that they have not given us. But he can probably give them to us within the next week or so.
Oh, yeah, but Mr. Burkett, then we get here and all of the judges are busy and you're asking for an adjournment and this gets put over to another day and just clogs everything.
Okay,
So
well, you know what?
you guys need to get all of the discovery that you need set. I'm going to adjourn the probable cause. I'll adjourn it to March 6, 2025, 9 a.m. You guys can give me a status report regarding discovery and then I'll set it from there.
And Mr. Burkett, have Patricia email me with what it is you're looking for.
Bond will continue. Thank you.
Thank you. Judge, have a good day.
Yep, you too. Court calls the case, People versus Andrew Johnson.
Ready, Your Honor. May it please the court, Robert Hamburger, retained counsel on behalf of Andrew Johnson, bar number P14570.
There we go. Sorry. Your name. Andrew Johnson. Thank you. All right. What are we doing on this?
I think we need to set a preliminary exam date, Your Honor.
Is all discovery complete, sir?
Yes.
We'll be ready to go on the 25th.
We'll do our best, Your Honor.
That work for you, counsel?
Not really. I have a case on the 24th that should carry over. So I would ask for.
I'll call you lucky. What about March 4th?
March 4th, I have a jury trial on the 3rd. So that could carry over. So I would ask for March 11th if that suits the court.
Well, should I have to? Counsel, is that a problem for that day? All right. Preliminary examination in person, March 11th, 2025, 9 a.m. That will be before Judge Perry. Bond continue. Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Jack Moniz.
Andrew Childers appearing on behalf of the people.
And Joshua Kaplan on behalf of Mr. Moniz. Jack, will you just state your name for the record?
Jack Moniz.
Your Honor, I know today's date and time set for probable cause conference. We did get the discovery. I was hoping to have some talks with the people. I was going to ask for one more adjournment on this case. There's been some new evidence that I would like to talk to the prosecution about before setting it for exam if need be.
All right, very good. Hearing no objection, set probable cause conference March 6, 2025, 9 a.m. or as your invite indicates. We'll continue. Thank you, folks.
Thank you, Your Honor.
Court does call the case of the people versus Cody, is it Tournier?
28, Your Honor.
Tournier.
Good afternoon, Your Honor. Charlotte Steffen on behalf of Mr. Tournier.
Mr. Tournier.
All right. All right. What do we do? You want an adjournment?
Yes, Judge. We are still looking into potential mental health programs for my client. I understand the people we're on the same page. We just need a little bit more time if the court is willing.
Yeah.
We're gonna try and look into mental health orders right here, as well as my county options, to kind of give us an idea of what we can do.
Got it. Agree. Oh, all right. What do I give you for, will the 13th of March work for you? I know you guys are working hard trying to figure something out, so it's
Yes, that's a good day for me, Your Honor.
13th. All right. Probable cause conference will be, well, I'm sorry. I do see that, and you don't have a medical marijuana card, do you?
I've been trying to find a way to get one. It's something new to me.
Pardon?
It's something new to me. I haven't been through the process, so it's taking a little bit more time.
All right. I do see the progress report. I'm not gonna, given what council's trying to work toward, I'm not gonna do anything with that, but you need to work on getting that, okay?
Okay.
You hear me?
Sure.
So,
I do have a question, Your Honor.
yes, sir.
As well as I went to the Saline precinct to get my fingerprints done, and I got told that that couldn't happen because I didn't have a paper from you, or from the courts, for that matter.
For the fingerprint. Should be one. You think so? All right, here's what I'll do. I'll adjourn this out to the 13th of March. Bond will continue. And I'll hand this off to my staff. There should be one in the file. We'll get your copy. If it's not in the copy, we'll print one. I'll sign it. Make sure you have it before you leave it there. How's that sound? Okay, all right.
Appreciate you, Your Honor.
Thank you.
All right, so just have a seat. All right.
That's it for that block. I got my 3 o'clock block coming up. Court's gonna stand in this. Oh, I got a search warrant. All right, and officer is on.
Officer Christie.
Yes, Officer Christie.
Oh, Judge.
Oh, there you are. Okay, sir, can you please raise your right hand? Do you solemnly swear or affirm the information contained in the search warrant and affidavit is true to the best of your knowledge, information, and belief?
Yes, sir.
All right. I will sign off on this and we'll get this over to you shortly. All right?
Thank you, sir.
Thank you, sir. Stay safe out there, please.
Will do.
All right. Here's this. All right. And court's going to stand in brief recess. Let's call the case of people, state of Michigan versus Donald Spaulding.
Good afternoon, Your Honor. For the record, my name is Arnold Weiner, counsel for Mr. Spaulding. Mr. Spaulding, if you're logged in, state your name for the record, please.
Donald Spaulding.
Do you have any objection proceeding by Zoom?
No.
Thank you.
Counsel, this is your motion. Go ahead.
Actually, Your Honor, if I may, I'm sorry.
Okay.
I emailed, so as the court may or may not know, I just got assigned to PCCs. And so I just got the, I believe I got the motion on Monday. Thought someone else was gonna answer it. Long story short, I'm asking for an adjournment so that I can review this file. I did send that email to Mr. Weiner last evening or yesterday afternoon, letting him know that I was just assigned to PCCs. Hadn't had an opportunity to look at this file and respond to his motion properly, so I'm respectfully requesting a short adjournment.
That's
Weiner?
that's a correct statement, Judge. She emailed me that she just got in on the case, and I have no objection to that. So
Okay.
I have not. Well, we've already waived the 21-day rule, and Mr. Spalding is out. So whatever time period that she needs, we can.
How much time did you need to respond?
I would like to set this out in springtime so I don't have to worry about driving from Pontiac to Ann Arbor and get caught in a snowstorm, Judge. So
Look, there's only one snow. You're a Michigander. You'll deal with it. Because we do.
Well, I tried. I tried.
Ms. Curry, you're here every other week, correct?
Every other week, so today's the 13th.
So why don't I put it out to March 13th and you answer within 2 weeks? Will that work for you?
March 13th? Yes, Your Honor, thank you.
All right.
Okay. Is that going to be in the afternoon or morning, Judge?
It will be in the afternoon.
Okay. Is that going to be in letter PCC, correct?
So what I do is Mr. Weiner, I'll set my PCC. I'll set the PCC as well as the motion. But when I'm dealing with extensive motions, we put them in the afternoon.
Okay, so we can do this by Zoom then also?
Yes, if you file the paperwork, we can figure that out for you.
I filed it for today, so I'll file the same thing for the 13th, and then we'll wait for a time period. Thank you.
It'll be March 13th, 2025, 3 p.m.
Okay. And I'll file the request for Zoom, Judge. Thank you very much.
Thank you.
Thank you, Mr. Weiner. Thank you, Judge.
Thank you.
And please give me a call, ma'am. Thank you.
I will.
And court does call the case of the people of the state of Michigan versus Zachary Rao.
Good afternoon, Your Honor. Jacob Kennedy on behalf of the people.
James Thomas on behalf of Mr. Radcliffe.
I don't know, Johnny, on behalf of Mr. Radcliffe, Your Honor. I do believe that we filed an appearance on my behalf of Mr. Radcliffe.
Yes, we have the appearance. Mr. Radcliffe is now present in the courtroom. And sir, if you could say your name so that the camera comes toward you so they can see that you're here.
Yes, Zach Radcliffe.
All right. So he is present in the courtroom. Just by way of introduction in this case, so that everybody's up to speed is in terms of what happened on last Friday. What date is that? The 7th. Well, even before then, counsel for defendant had filed a motion to dismiss, filed a supplemental pleading that contained letters of support for the defendant that the court reviewed. That came through as a filing to the court. On the date of the motion, on the date of the hearing, certainly there were people in the courtroom that were agitated. Certain people came to our attention just in terms of their actions and other things, both my attention as I was looking out at who was here, as well as my bailiff's attention. There was one individual that my bailiff had reported to me that he spoke to just to make sure that there was nothing that was going to occur. Subsequent to, so that was on a Thursday, and I don't believe that it was the next Thursday. My dates are a little off a little bit here, but anyway. At that hearing also, Mr. Thomas presented additional letters of support for the defendant. I received those at the bench. They did not sort of come through and were filed as that supplemental report was. I retained those in my office file because of the way that they had come to me. I had taken a break during that proceeding at some point and reviewed those. That next day, the same individual that my bailiff had spoke to, as well as the person that had come to my attention. It was reported, well, we found out it was that same person eventually, but my clerks had reported to me that someone was at our front counter seeking to get the information regarding who had supplied the letters of support, specifically the ones that Mr. Thomas had presented to the court in court that day. That raised an alarm on the court's part as to why someone would want that information. I guess so that the record is all clear, I then got the file from the clerk's office, set a hearing, had my office email counsel, set a hearing regarding a protective order or something regarding those particular activities, and basically held the file so that until we could sort of resolve or try to resolve this issue. We were informed, I don't have the entire email, certainly counsel could speak for themselves. Upon setting the hearing, I think Mr. Thomas had indicated that he was looking into things as some of the people, and Mr. Thomas certainly correct me if I'm wrong on this, that had supplied those letters, that they had been doxxed in some way and their information in some way disseminated or provided. The prosecutor's office also made me aware of, after that, but prior to the hearing, that there are individuals, and I'm going to say it in this way, that could potentially be viewed as acting in concert with the defendant. And when I say it that way, I'm not saying that they are. I'm just saying it could be viewed that way. We're contacting victim or victims' families in regard to this case. And so that was the last kind of thing. There was certainly an email regarding certain discovery issues and other things that went back and forth. But the purpose of the court's hearing today was to hear from counsel and to try to figure out, if we can, a way that this can be alleviated, and use what powers the court has to try to stop it from occurring while everybody proceeds to this process. All right. I say that all as a preface. That's kind of where we are. I think both sides kind of do most of that, if not all of that. And I'll do that. So, Mr. Thomas, maybe it makes more sense to sort of hear from you, I guess, because you were looking into some things in regard to it. So,
Yes, sir. So I'm going to leave the names out for purposes of, I don't want to put them on the record, but I was contacted by supporters of my client, obviously, and I had learned that there were names that were being doxed from the letters that we submitted as an attachment to our supplement. Obviously, it rose concerns because I didn't learn of that till obviously after the hearing had already been conducted. Had I thought about it, I probably should have submitted them under a protective order in the first place. So that's kind of on me that I didn't do it that way. I just didn't think that it was going to rise to the level of where we're at right now with the people on the other side of this equation. To address the court's concerns regarding whether these people are in concert with my client or not, I can assure you that I've had meetings with most of the people that are involved, the ones that have been coming to the normal court dates, and I have specifically told them, do not talk to these people, do not reach out to them, do not call them, do not email them. They all know, the family knows, and everybody else knows not to engage with them in any sort of way, and they have not. We have not gotten any reports from anybody that anybody from the defendant side have contacted anybody on the prosecutor side. Now, that's not the same that we're getting from the other side. Of course, we're getting messages from people, and I really don't want to go there because I'm not personally involved in this, Judge. I'm the lawyer. I have a job to do to defend my client. I'm not personally involved with the emotions that are involved in this case. I'm a lawyer. I'm a lawyer that protects the Constitution and my client's rights. And so that's how I feel about it. That's what I've been engaged to do. I am technically a mercenary to defend my client, and that's it. The emotional stuff that is going on between the families and of the victims and the family of the defendant are, to me, those are things that should not be in the courtroom. Obviously, at some point, I'm going to address those things because if we end up going to trial and there's noises or gasping in the crowd, I'm going to move for mistrial, and I'm going to do whatever
I don't need to know your trial strategy, counsel. I really don't.
No,
that's not what I'm here for. I'm not here to talk about you. I'm not here to talk about anybody. I'm here to try to deal with making sure that things don't come out of this that I don't think any of the parties here intend. And so when I set this, my issue was to certainly listen to counsel as to how to do things. There is a individual, and what I will do is I will have my staff, and rather than put the name on the record or the phone number that's contained in here, can we scan and send? I realize I only got you, but
No, it's okay.
can I scan and send this to Mr. Thomas and we'll address it?
You want this done right now?
Yeah,
Yes.
I want that done so that we have that.
If I may just say one more thing about these letters, they've been put out on social media, and they're being used specifically to attack the people on social media and the church that my client's father is the pastor at. So they're doing it for other reasons other than just to retaliate. They're doing it to try to punish them economically, socially, and everything else, trying to shame them. So it goes a lot deeper. So do I think a protective order needs to be put in place by the court, for this? I absolutely. Again, it's your choice. You can do whatever you want. And again, I'm not, personally emotionally involved in this, but obviously if the court thinks that, this has gone above and beyond what needs to be done. This is a one defendant that there's allegations against, not the family, not the church, not the pastor, and for these people to go and take these letters that people that support my client has got no bearing on those other things. They're doing it just to be ugly. And so I think the court can use its discretion to put a protective order in place against that if the court so deems. My other concern is that those letters I gave the court, I did not file. And so I told the court that I was going to file them until I learned about the doxing, and I decided I was going to hold off to see exactly what was going on social media. So I don't know how you want me to address that. If you want me to
You're talking about the letters that you presented in court?
Yes, sir. The ones that I
Okay.
didn't have time that we submitted, that I got at the last minute. So there's nothing in the record other than you saying I got them, and obviously the names and all that are not part of the record. But if you want us to do it under a protective order, to submit those other letters that I gave you, so they'll be part of the file but be protected, I'm happy to do that if that's what the court wants me to do.
Understood. Mr. Kennedy.
Yes, Your Honor. Just a couple of things. As the court knows, I, as well as Ms. Reiser and the rest of our team on this matter, were not aware of any doxing taking place until just now. It's been indicated by Mr. Thomas. I do want to make sure that I'm clear as to what has actually transpired. If there are these letters that are being placed on Facebook, of course, I am concerned about people's personal information being placed out on social media platforms. I will say, however, that simply being present in the courtroom would indicate to others, I mean, we were all there on the night of the hearing, being present in the courtroom and sitting on a specific side indicated to the public and those who were within that proceeding who was being supported. And therefore, those members of the courtroom going out and indicating to others that so-and-so was on his side, so-and-so was on our side, is simply something that I don't think can be controlled. I don't think that it can be controlled in terms of the community of Saline, in terms of the greater Washtenaw County community. I think we all are certainly in an understanding that this is a case that has deeply impacted the community, has deeply impacted this church, and has deeply impacted the victims and the defendant. So I understand that protective order on the letters will certainly prevent this personal information that is placed in these letters from being further disseminated to the public. And in safety concern being of the utmost priority, I would agree with Mr. Thomas, and I would agree with the court. I believe that a protective order would be warranted, but I don't think that it's almost as if this has gone to the point of no return almost. Simply being physically present in the courtroom and sitting on an individual's side indicates a support. And we just simply cannot control what people are going to say within their own community about those other individuals. So I am concerned about the doxing. I would ask this court to please make me aware if there's anything else that has happened. And as I've indicated previously, we were unaware. I've spoken with the officer, spoken with our victim advocate, and they were also unaware that any doxing had taken place prior to this week. So all that is to say, would be in favor of a protective order in order to secure the safety of the community. And I would like to say thank you to the court for bringing this to our attention. It is indicative of the court's desire to make sure that the community is safe.
And here's what I'm going to, and having listened to both sides, here's what I'm going to do, unless I hear an objection. Mr. Thomas, the supplemental document, the attachments to the supplement, the letters that were contained, I'm going to separate those out. I'm not going to strike them, certainly, from the record. But what I'm going to do is I'm going to place those as well as the other letters in a confidential portion of the file that won't be released to the public if somebody comes to look at it. I'm basically going to put a sort of check system in place that if somebody wants to look at it, it should come to the judge and then make a determination. So if for whatever reason you needed a copy of it, or somebody from your office needed a copy of it, you wouldn't be able to walk in and get it, but you contact the court, we would be able to get a copy to you. That way, I think because I have to balance making sure that the record that's there is complete, with the same time not making sure that individuals can't walk in. So that's the first thing that I think the court's going to do. I would also indicate to counsel that and I will draft an order to that effect as to what specifically I'm going to do. But I would also indicate to counsel that if there are other documents or other things that would contain personally identifiable information, almost defined in its broadest sense, that you provide a copy to the court if you are filing it, that you redact that information from what is filed, so that the contents of whatever, so if there were the letters, the redaction at the top of maybe name and certainly address and phone number and email would be done, so that it could be filed. If you have a question as to that or some issue, then certainly at any point you can bring that to the court's attention on that. I would also indicate that, and I understand Mr. Thomas's position in terms of his obligation, certainly to his client, and the like, but I think all of us as officers of the court are responsible for the operation of the court. the smooth operation of the court and making sure that people are able to participate in our system without any fear or favor. So I do think there is an obligation on council to say something that doesn't obfuscate what one's primary objective may be. But I think that obligation does go there, and I would encourage council to talk to all of those individuals involved. I have, Mr. Thomas, had my staff send to your office a text message. I am not, did you emailed that with an attachment to it?
I did, sir.
All right. And I'm not going to say the name of the person. This, as I look at it, this is alleged to have been sent to one of the victims. It is also alleged that the individual sending it is a member of your client's family in some way. So I doubt very much I'm going to do anything with that at this point in time. I want you to be aware of it. And I think, as I would say, with your obligations, I think that any member of the bar has its obligations to the court and our system, that you take some appropriate action potentially to address it with that person, or since the person is related to the defendant, as I'm to understand, maybe something from the defendant regarding that would also be helpful. But I will leave that to your discretion as to what to do with that. I mean, when I look at the contents, I could frankly take it in a way that it sort of means nothing. I could also take it in a way that it could be the beginnings of a threat. And so I just don't know what it means. I'm trying not to jump to any conclusion regarding that, but I think somebody may be lashing out, or the defendant. But sometimes you can have family members that lash out. It's not always necessarily in one's best interest. They're lashing out because of what they feel and what they believe. Okay. So what I will do, and I will leave it at this, council, I will, having heard from you, I will prepare an order. This has been a heck of a week, so I will try to get it out by Monday to council so that you have it, you can look at it, or actually Tuesday because of the holiday. And so that you can look at it. In the meantime, as I've indicated, the letters that were filed with the court are going to be placed in a confidential part of that file that no one will have access to. All right.
So
anything else?
Need to do with those letters in, Your Honor?
Pardon?
So you're saying I don't need to do anything else with those extra?
No, you don't need to do anything. We'll be good with that. The court has reviewed them. The court's made its ruling on the motion. I don't need that. They'll be part of the file, just not where someone can access.
All right.
Okay.
Yes, sir.
All right. Anything else from either side?
Yeah, maybe.
Your Honor, if we just let the prosecutor know, we will email him some additional information requests. We don't want to take up the court's time on that, but we will send it out this week.
Well, I'm sure they'll look forward to getting it and seeing if they can respond.
Thank you, Your
All
Honor.
right, folks. Okay, thank you very much.
Thank you,
Your Honor.
That concludes this matter. Thank you, folks, for bringing them up.
Yes, it is.
14.